And under point 4, please, we see this under roles and responsibilities. Project Sparrow should be split to separate the mediation scheme from business improvements. AVDB, so is that Angela van der Bogert?
Yes.
To be Programme Director for the Business Improvements Programme. BC, is that you?
Yes.
To be Programme Director for Sparrow. And there's an action there, AV, DB and BC, to agree how the split will work with CA, so is that Chris Ojard?
Yes.
How did the split between you and Angela van den Bogert work?
So the business improvement programme was the response given to Angela for to be programme director, and everything else at the time, I don't know whether I fully understood what everything else was, but everything else would come to me. The caveat around that was the investigations into the specific complaints in the scheme would be conducted by a team, or actually 2 teams that were established by Angela. So although the investigations were relevant to the scheme itself, as opposed to almost being tangential to it, Angela had responsibility for the investigations and the cases, and I did not.
That document can come down now, thank you. You say at paragraph 8 of your statement that you completed your outstanding work on mutualisation between October and December 2013. Was that alongside your work on the scheme and Project Sparrow?
Yes. So I think, to the best of my recollection, Sir Anthony Hooper was appointed and was keen to have a working group meeting. So my secretariat responsibilities started relatively quickly. In terms of everything else, I would say as the process continued, it wasn't a straight cut-off point at the 25th of November. The mutualisation work ran down and the mediation work ramped up.
And what became of the proposal for mutualisation?
So at that stage in the process, it was split between the Communications Directorate, looking at the public purpose of the Post Office, which would have been an underlying statement of what the Post Office stood for, and then the strategy to mutualise the Post Office stayed with Strategy Group, where it had sat when I was working on it.
You then started a fixed-term contract which made you an employee of the Post Office, is that right?
That's correct.
And that was on the 1st of January 2014?
Yes.
You've corrected in your statement the reference to full-time to fixed-term.
Yes.
Were you working full-time hours?
Yes.
You say at paragraph 11 of your statement that you also provided a support function for the new Post Office General Counsel, Chris Ojard. What did this role entail?
So this was specifically to assist him in meeting any requests from either the working group or the board in the general area of work which fell into not necessarily a direct result of the mediation scheme, but any issues that the particularly the Post Office Board wanted to address in order to inform any decisions they wanted to make to the scheme. It was it was a pulling together of anything that he needed pulling together that was in any way related to matters relating to the scheme.
Is it right that your fixed-term contract with the Post Office ran until the 31st of March 2015,
That's correct.
at which point you retired?
Yes.
I'd like to turn, please, to your knowledge of bugs, errors and defects and your understanding of their significance, not now, but at the time that you were at the Post Office.
Yes.
At paragraph 15 of your statement, you say that you were not aware of the abbreviation for bugs, errors and defects, that is BEDS, during your time within Post Office. You do recall, though, being aware of the matters raised in the interim second site report of July 2013.
Yes.
Right? And you also say at that paragraph that you became aware of such issues being raised by the Justice for Sub-Postmasters Alliance, as well as applicants in the scheme.
Yes, not specifically related to bugs, but just concerns about the Horizon system.
Looking, please, to the interim second site report itself. Could we have that on screen, please? It's POL 30099063. We can see the title there, Interim Report into Alleged Problems with the Horizon System. And then going, please, to page 8. Towards the bottom, we have the date, the 8th of July, 2013, and the redacted signatures of Mr. Henderson and Mr. Warmington. And the preliminary conclusions are set out above at 8.2. And these were as follows. A, we have so far found no evidence of system-wide systemic problems with the Horizon software. B, we are aware of 2 incidents where defects or bugs in the Horizon software gave rise to 76 branches being affected by incorrect balances or transactions, which took some time to identify and correct. C, occasionally an unusual combination of events such as a power or communications failure during the processing of a transaction can give rise to a situation where timely, accurate and complete information about the status of a transaction is not immediately available to a sub-postmaster. D, when individual sub-postmasters experience or report problems, POL's response can appear to be unhelpful, unsympathetic or simply fail to solve the underlying problem. The lack of a user forum or similar facility means that sub-postmasters have little opportunity to raise issues of concern at an appropriate level within Post Office Ltd. E, the lack of an effective outreach investigations function within POL results in POL failing to identify the root cause of problems and missing opportunities for process improvements. And F, the end of trading period processes can be problematic for individual sub-postmasters, particularly if they are dealing with unresolved transaction corrections. The lack of a suspense account option means that it is difficult for disputed transaction corrections to be dealt with in a neutral manner. Then going back, please, to paragraph 6.4 on page 5. This is under the section on whether defects in Horizon caused some of the losses for which sub-postmasters or their staff were blamed. And it says at 6.4, in the course of our extensive discussions with Post Office Ltd over the last 12 months, Post Office Ltd has disclosed to Second Sight that in 2011 and 2012 it discovered defects in Horizon Online that had impacted 76 branches. And over the page, please. The first defect, referred to as the receipts and payments mismatch problem, impacted 62 branches. It was discovered in September 2010 as a result of Fujitsu's monitoring of system events, although there were subsequent calls from branches. The aggregate of the discrepancies arising from this system defect was £9,029, the largest shortfall being £777, and the largest surplus, £7,044. Post Office Ltd has informed us that all shortages were addressed at no loss to any sub-postmaster. Then the second defect is addressed at the next paragraph, the local suspense account problem, affecting 14 branches and generating discrepancies totalling £4,486, including a temporary shortfall of £9,800 at one branch and a surplus of £3,200 at another. The remaining 12 branches were all impacted by amounts of less than £161. Goes on to say that Post Office was unaware of this second defect until a year after its first occurrence in 2011, it reoccurred and an unexplained shortfall was reported by a sub-postmaster. The initial investigations by the Post Office in 2012 failed to reveal the system defect, and because the cause could not be identified, the amount was written off. Fujitsu looked into the matter early in 2013 and discovered and then corrected the defect. It seems, however, that the shortfalls and surpluses that occurred in the first occurrence in 2011 resulted in branches being asked to make good incorrect amounts. Post Office Ltd has informed us that it has disclosed in witness statements to English courts information about one other subsequently corrected defect or bug in the Horizon software. Forgive me for taking you through that at some length, but I'd just like to be clear about the issues that were being raised in the interim second site report.
Yes.
And the report was, in fact, making reference to 3 defects or bugs in total, which second site had been told about by the Post Office. Would you agree?
Yes.
You say at paragraph 15 of your statement that you were not aware of concerns being raised within the Post Office about bugs, errors or defects, or a lack of integrity in the system. But aren't these 3 defects or bugs identified by the Post Office to second site an example of that? Concerns being raised by the Post Office?
Sorry, could you repeat the question?
Forgive me, that was a long question. In your statement, you say, and if you'd like to go to it, we can. It's paragraph 15 of the statement. Which is page 6. I referred earlier to the sentence before this of becoming aware of such issues being raised by Justice for Sub-Postmasters Alliance and applicants in the scheme. And you say I was not aware of concerns being raised within Post Office Ltd about BEDs or bugs, errors or defects, or a lack of integrity in the Horizon system. What I'm asking is those defects or bugs which were referred to in the interim second site report, having been raised by the Post Office, were they not an example or examples of concerns being raised within Post Office about bugs, errors or defects?
I see. So at the time I became involved in this, it was my understanding that Post Office believed that it had addressed the issues raised in the second site report satisfactorily, and therefore, beyond that, it continued to have confidence that Horizon was working as it should. Therefore, and because these issues, these particular beds had been highlighted, publicised and addressed, my understanding within the Post Office was that almost there was a line drawn under that, But moving forward, there was a considerable level of confidence in the fact that Horizon was working as it should.
One of the preliminary conclusions that we've just been to was Second Sight raising concern about the Post Office failing to identify the root causes of problems. In light of that, did you not have any concern that there might be other defects or bugs, using Second Sight's terminology, that had not been discovered?
At the time, no.
That document can come down now, thank you. When you took up your role with the scheme and Project Sparrow in 2013, were you aware that the Post Office had brought prosecutions against sub-postmasters and others privately based on Horizon data?
I was aware that Post Office brought prosecutions. The detail of that, or more detail of how that worked, for example, that Post Office was not a prosecuting authority, it was private prosecutions, was something I became aware of a bit later. The actual evidence used in the prosecutions was not something that I was particularly aware of or particularly concerned myself with. It became the subject of discussions later during the lifetime of the scheme between Post Office and Second Sight.
Were you aware when you took up the roles in 2013 that action was being taken against sub-postmasters by the Post Office, including by way of civil claims and debt recovery actions, to recover shortfalls in agency branches?
I certainly became aware of that during the first couple of months, I would say.
When you read the interim Second Sight report, did you recognise the significance of it for individuals against whom the Post Office had taken action?
No. I read it by way of background in terms of what had gone before, as opposed to particularly engaging in the detail. The only detail I engaged in was subsequently in relation to, I think, was Spot Review 5. But beyond that, it was more by way of context for the work that I was involved in, as opposed to me being involved in any sort of investigation of the issues.
Could we have on screen, please, POL 00302417? This is an email from, if we can scroll down a little, Angela Tanner, Stakeholder Correspondence Team. Can you help us with that team? What was that team's role?
I think that was just the team that dealt with any lessons, any correspondence that came into Post Office generally.
And this was sent to you, copied to Angela van den Bogert, along with one other. It is dated the 27th of February 2014. And it reads, "Hi Belinda, please find attached a letter sent to Paula regarding a Horizon integrity concern. I have spoken to Gail today and she has advised me that you are the person to help me. The letter is from Oliver Heald, QC MP, on behalf of Mrs. Jasvinder Barang, who was a sub-postmaster until her contract was terminated due to fraud. She believes that there was an issue with her Horizon system and would like her case to be considered under the mediation scheme. Both Oliver Head, MP, and the sub-postmistress are aware the closing date was the 18th of November. Not sure if this case can be looked into. Please advise what we can do. Do you recall this case being referred to you at all, given it was referred via an MP?
No.
Can you help with why you would have been the person to help?
Because it related to a potential late application to the scheme, and I was the secretariat to the scheme. At that point, the scheme had closed to new applicants, and I can't recall the point at which there might have been a change of process, but initially we did have some late applications to the scheme, and they came sometimes through correspondence to the Post Office, sometimes through correspondence to Second Sight, and my job as secretariat to the working group would be to put them on the agenda for the working group to make a decision as to whether or not the cases should be admitted. After a period of time, I think that the working group had decided that late applications should not be accepted, but the cases would be passed to Angela van den Boga to investigate as part of her business as usual processes. So the reason I explain that is I can't recall this case, and I don't know whether or not I would have put it as an agenda item for the working group, or by that time the working group would have decided that that it would be passed immediately to Angela.
So should we understand from that you were not involved in any investigation of the facts of this case?
No.
Or that document can come down now, thank you. You have addressed the Helen Rose report in your statement at paragraphs 80 to 83. If you wish to refer to those paragraphs, do. And in particular, you have referred to email correspondence from April and June 2014, in which the report was addressed. Your evidence at paragraph 80 is that you think you believe you became aware of the Helen Rose report in 2014, but you do not think you appreciated at the time the extent to which the contents of it may have been important to sub-postmasters who had been convicted of relevant offences on the basis of Horizon data. Is that right?
I'm sorry, could you take me to the paragraph again?
Of course, it's paragraph 80.
80?
Yes.
Sorry, 80.
80. We can have that.
I apologise.
It's page 39.
Yes. Yes.
So you say, I believe that I became aware of the Helen Rose report at some point in 2014, although I do not recall exactly when. Following my review of the report and the email correspondence around the matter, I do not think that I appreciated at the time the extent to which the contents of it may have been important to those sub-postmasters who had been convicted of theft, a fraud offence or false accounting on the basis of data generated by the Horizon IT system. Could we have on screen, please, POL 001 48049? And page 3 of this document, please. About halfway down the page is an email from Steve Darlington of Howe & Co. to Ron Warmington, dated the 8th of April 2014. And the first two paragraphs of his email read as follows. As Priti has stated in her last sentence, we are seeking a stay on the time limits on all cases under review due to the implications of Post Office Ltd's non-disclosure of system-generated transactions and Horizon's integrity issues. The Helen Rose report is of critical significance to all cases. The information contained within it is a compelling case for such a stay in its own right. When combined with the Andy Wynne/Alan Lusher email in the case of Ward, which explicitly states that Fujitsu can remotely change the figures in the branches without the sub-postmaster's knowledge or authority, the case for a general stay is overwhelming. We will come back to the second point being raised here, and that being the point of the case of Ward and the email referred to. But sticking now with the Helen Rose report.
Yes.
Scrolling up to the email above, please. We can see here Mr. Warmington forwarding Mr. Darlington's email to you, proposing this for that week's working group call. Do you see that?
Yes.
And then scrolling up again, we see that you forward the email from Mr. Warmington onto Angela Vanden Bogert, Andrew Parsons, Andy Holt, and Roderick Williams, also on the 8th of April 2014. And that email was copied to Chris Ojard and David Oliver. And you say this, please see below, not yet decided about whether to postpone this week's WG call, but does anyone know anything about the email being quoted below about remote alteration of the figures in branch? I think this one is new on me. As I say, we'll come back to that. Andy P, can we please chase CK, so Cartwright King was that?
Yes.
For a response on the Rose report point. Do you recall this coming to your attention in this way, the Rose report reference, looking at these documents?
From reading these documents, I assume that the issue of the Rose report had arisen previously, and I had asked Andy Parsons for presumably some briefing to ensure that Chris Ojard and Angela had what they would require for any discussion at the working group.
Could we have on screen, please, POL 29707. This is an email later on the 8th of April 2014 from Andrew Parsons to you, among others, providing some information, having spoken to Cartwright King. And he addresses an issue in his email relating to redactions applied to the report before providing some background information in his penultimate paragraph on the Helen Rose report. And he says this, just for background information, the material part of the Helen Rose report has nothing to do with her comments about reversal data. SS, is that second site?
Yes.
And Howe, being Howe & Co, are taking this point as evidence of a problem with the integrity of Horizon. In fact, Helen's issue was that the credence data, although accurate, did not on its face clearly distinguish between automated reversals and user-generated reversals. This information is available but in a different report. The concern was not with the data's accuracy, but that the presentation of the data could be misleading if its limitation were not fully understood. Putting this issue aside, the real, and in brackets, and confidential reason that the report was disclosed was because Helen's comment at the bottom of page 3 suggests that it was widely known that there were problems with Horizon. This statement, brackets regardless of whether it is correct, could have been used to attack Gareth Jenkins' credibility as Post Office Limited's Horizon expert, as he had previously stated that there were no problems with Horizon. So Mr. Parsons is flagging up, is he not, that the Helen Rose report had implications for the credibility of Gareth Jenkins?
He is, and I can now see that. At the time, that is not the way that I would have read this email, to the extent with which I would have engaged with the detail.
At the time, did it concern you at all, that particular aspect in relation to Gareth Jenkins' evidence?
No.
Could we have on screen, please, POL 00202810? This is an email from Andrew Parsons to you dated the 9th of April 2014, so the next day. I appreciate this is a document which has only been provided to you very recently. Have you had a chance to read through it, or do you want to take a moment to just read through now?
No, that's fine.
It reads as follows: Andrew Parsons to you, copied to David Oliver. Belinda, FYI below and attached. This is the original Helen Rose report and the original email chain. I can't find anything after this date in our records, as I think that Roderick took over from this point. Clearly, at some point, this document went to Cartwright King, and Cartwright King produced the attached advice in July 2013 that triggered the disclosures of the report to some convicted sub-postmasters. There are two attachments to the email that we can see just under the subject there. You can see attachments, Horizon Data Lepton, SPSO, confidential doc. And then the second one, Gareth Jenkins advice, 5th of July 2013. And that second one is the Simon Clark advice, Simon Clark of Cartwright King, on the use of expert evidence relating to the integrity of the Fujitsu Services Limited Horizon system. Did you read the Rose report itself when it was sent to you by Mr. Parsons?
I don't recall whether or not that was the point I read the Rose report, but from the previous, or from a previous email, I can see that I did read it because I queried some things in it and suggested that Chris needed briefing on it. But whether or not it was in response to the attachment to this, I don't know.
Did you read the Simon Clark advice of the 15th of July 2013 when it was sent to you in this email?
I have absolutely no recollection of that advice. I am quite surprised to see that here, because up until this point, I would have said I had no knowledge of it whatsoever.
You say you have no recollection of the advice. Would you have read the attachments to emails sent to you as a general practice?
So I think it depends on the context. So I would have considered my role to make sure that anybody that needed to know about anything in order to ensure that the work of the working group went smoothly and that they were properly briefed. So I commissioned briefing. I did not read everything that was sent to me. I suspect, because I have now read the Clarke advice, because it's been published in various formats, I suspect I might have opened it and started to read it, but not read all of it. I think it's quite long, and I certainly wouldn't have understood the significance of it, particularly in view of the fact that I believed that that Post Office had done everything it needed to assure itself that its prosecutions were safe. So this is something about which I would not have concerned myself, and I would have assumed that it was being dealt with by the criminal lawyers who were experts in the area. But I don't think I read it.
Did you ask anyone about the advice at all at the time, about what it was about?
I have no recollection at all.
Mr. Ojard's evidence was that he was aware of the Clarke advice. Did he ever raise it with you?
No, to the best of my knowledge, no.
Could we have the Clarke advice on screen, please? It's POL 406357. And going, please, to the last page, page 14. At the bottom, we can see the date and the author. You say that you have now seen the advice. Have you read it from start to finish now?
Pretty much, yes.
I'd like to take you, please, to paragraph 36. That's page 12. And without reading it all out, if you can just cast your eye down there. We see there at E the reference to Helen Rose's comment in her report. And so this is Simon Clarke explaining the significance of the comment.
Yes.
Reinforcing the point. I know you are aware of all the horizon integrity issues. And then at G, no mention is made of any of these horizon issues, those issues you see set out above, in Dr. Jennings' expert witness statements considered in this review. Rather, the statements attest to the robustness and integrity of Horizon. Then at paragraph 38, apologies, at H at the top there, had the existence of the bugs been disclosed by Dr. Jennings in his expert witness statements, then in relation to any defendant who had raised Horizon issues as part of her defence case, that material might reasonably be considered capable of undermining the case for the prosecution or of assisting the case for the accused, and would undoubtedly have required disclosure to such a defendant. Then at paragraph 38, at 37 above, Mr. Clarke makes clear that Dr. Jennings has not complied with his duties to the court, the prosecution or the defence. And at 38, the reasons as to why he failed to comply with this duty are beyond the scope of this review. The effects of that failure, however, must be considered. And he advised the following to be the position. Dr. Jenkins failed to disclose material known to him, but which undermines his expert opinion. This failure is in plain breach of his duty as an expert witness. Accordingly, Dr. Jenkins' credibility as an expert witness is fatally undermined. He should not be asked to provide expert evidence in any current or future prosecution. Similarly, in those current and ongoing cases where Dr. Jenkins has provided an expert witness statement, he should not be called upon to give that evidence. Rather, we should seek a different independent expert to fulfill that role. Notwithstanding that the failure is that of Dr. Jenkins and arguably of Fujitsu Service Limited being his employer, this failure has a profound effect upon Post Office Limited and Post Office Limited prosecutions, not least because by reason of Dr. Jenkins' failure, material which should have been disclosed to defendants was not disclosed, thereby placing Post Office Limited in breach of their duty as a prosecutor. By reason of that failure to disclose, there are a number of now convicted defendants to whom the existence of bugs should have been disclosed but was not. Those defendants remain entitled to have disclosure of that material, notwithstanding their now convicted status. And he goes on to explain he's already advised on the need to conduct a review of all Post Office prosecutions so as to identify those who ought to have had the material disclosed to them. That review is presently underway. Further, there are also a number of cases where there has been no disclosure where there ought to have been. Here we must disclose the existence of the bugs to those defendants where the test for disclosure is met. Where a convicted defendant or his lawyers consider that the failure to disclose the material reveals an arguable ground of appeal, he may seek the leave of the Court of Appeal to challenge his conviction. And at 39, in an appropriate case, the Court of Appeal will consider whether or not any conviction is unsafe. In doing so, they may well inquire into the reasons for Dr. Jenkins' failure to refer to the existence of bugs in his expert witness statements and evidence. Were you aware of the issues set out in the paragraphs that we've just been to at the time?
No. I have to assume that I did not read it because, and again, having looked at it with you here, even my lack of legal knowledge or lack of knowledge of criminal law would not have stopped me, I think, from at least asking what has happened in relation to this. So I must assume I didn't read it. I would, and I struggled to understand why Andy would have sent it to me, because disclosures and matters relating to disclosures was totally outside of my brief.
Had you read it at the time, what would your reaction have been?
Now?
Had you read it at the time?
Oh, had it? So, I would have questioned, I'm sure, of Andy, Jarnell certainly, and I would also have asked the question of Chris that what had happened as a result of this. I would say that I took most things that were not within my direct line of responsibility at face value in terms of what I was told. The reason I make that point is that particularly not having any familiarity with the subject matter, and in a big organisation, doing the job I was doing and also others, I was incredibly reliant on the completeness, the accuracy and the veracity of the information I was given. The reason I don't believe that I saw this is that I did continue to insert into briefing comments about Post Office's confidence in the safety of its its prosecutions. And I can't imagine that I would have done so had I read this. at least without having asked a question about it.
Going back to the email traffic on the subject of the Helen Rose report, please, and how it was to be referred to in investigation reports for the scheme, could we have on screen, please, POL 001 29392? Towards the bottom of page 2, please. This is an email from Andrew Parsons dated the 17th of June 2014. It is to Chris Ojard, Roderick Williams, John Elsing, Angela Vanden Bogert, and you, among others. And he says, I've just spoken with Cartwright King about a new CQR. Can you help with CQR? Is that one of the cases?
Sorry, so I was trying to think of the. I think it was the initial setting out of the complaint by an applicant in the scheme. I can't remember what CQR stood for, but I think that's what it was.
From Howe & Co. that references the Helen Rose report. You'll recall that the Helen Rose report was retrospectively disclosed in a number of prosecution cases as it drew into question some of the statements made by Post Office Ltd's expert witness Gareth Jenkins. A copy of the Helen Rose report has made its way to Howe & Co., who are now referencing it generally in their CQRs. For example, the CQR on M060 refers to the Helen Rose report. However, the Helen Rose report was not sent to this applicant. The point of concern is that the M060 CQR is starting to make the link between, one, the fact that the Helen Rose report makes clear that Gareth Jenkins knew of issues with Horizon, and two, the fact that GJ, Gareth Jenkins, never mentioned these issues in his prosecution evidence. See paragraph 53 in the attached. This line of inquiry draws into question the credibility of Gareth Jenkins' evidence. The sharing of the Helen Rose report between applicants is potentially a breach of solicitors' ethics / contempt of court. However, Cartwright King and I don't believe attacking the solicitors on this point would be a benefit. If anything, it may draw more attention to the Helen Rose report. Instead, our preferred approach is to try to downplay the importance of the Helen Rose report in any Post Office Ltd investigation reports. We recommend minimalising or ignoring entirely the Helen Rose report when responding to CQRs. If the investigation team need guidance on how to address any Helen Rose report-related questions, I suggest that they, or the lawyer here at BD, addresses these directly to Cartwright King on a case-by-case basis. And then he asks, please let me know if you're happy with this proposed approach. So regardless of the Simon Clarke advice, would you agree that Mr. Parsons was joining the dots in quite clear terms in relation to the implications of the Helen Rose report for the credibility of Gareth Jenkins?
Yes.
And in light of that, did you think his preferred and recommended approach for cases in the scheme was appropriate?
So, looking at the two things separately, because I have considered and reflected on this email, the linking of the Helen Rose report with the credibility of Gareth Jenkins' evidence, I did not. Now, as with the previous email, now I read it again, I understand, and knowing what I now know, that the statement about starting the point of concern is that MR60 CQR That is far more significant than I realised at the time. I suspect I would have skimmed over that. The issue that is, I think, a matter of regret for me is, among many, if I may say so, but regardless of my knowledge, regardless of my expertise or otherwise in law or criminal law, I don't think an approach to try and play down the importance of the Helen Rose report is satisfactory advice. And the reason for that, and particularly in terms of the spirit of the scheme, is that if it were not important, and my assumption throughout the whole of this time was that it was not as important as it was being made to be, and I accept that assumption is now proved to be incorrect, that if it was not important, then that should have been clearly stated in response to any reference to it in a CQR, and the reasons why. And I wish, and indeed on reflection, I should have challenged that. I can't say exactly why I didn't do that, but we very much, if you like, segregated the matters with which we were dealing with. So insofar as I read this and engaged with it, it would have been, this was in advice to the investigation team, and I wasn't involved in the putting together the investigation reports, and I would not have read a lot of the associated documentation.
In August of 2013, Simon Clarke had cause to write an advice which advised the Post Office on its duties to record and retain material. And in that advice, he referred to having been provided with information to suggest that there had been an instruction by someone within the Post Office that minutes of a conference call about horizon integrity should be shredded. Did anyone ever raise that advice with you, or that issue with you?
To the best of my knowledge, no.
So I wonder if that might be an appropriate moment for the first morning break.
Yes, but before we do, can I just ask you this? When Miss Price was asking you questions, upon the assumption that you had read what I'll call the Clarke advice, you said that you thought if you had read it, you would have questioned Mr. Parsons, Jarnell, and Mr. Ujard in some way to understand its significance. All right?
Yes.
That's what you thought you would have done.
Yes.
And they are obviously all internal, if I can put it in that way, to the Post Office.
Yes.
Would you have thought about what your duty might have been as the secretary of the scheme to inform Sir Anthony Hooper as the chair of the working party about that document?
So all of the issues, that arose in relation to Horizon or indeed prosecutions had a much wider application than just those cases in the scheme. So I think I would have wanted to understand the situation before I did anything wider. If I might take your point slightly further, if I had read this and had asked questions about it and was not satisfied with the response I got, then I think Sir Anthony Hooper, as opposed to going to the working group, would have been a person that I would have discussed this with.
All right, thank you very much. Yes, what time should we start again, Ms. Price?
15:15, sir, I think is 10 minutes.
Fine, okay, thank you.
Thank you. Hello, sir. Can you still see and hear us?
Yes, thank you.
Turning, please, to the issue of remote access to the Horizon system. You address this and you define remote access as the ability of Fujitsu employees to alter transaction data or data in branch accounts without the consent or knowledge of sub-postmasters. And you address that at paragraphs 18 to 25 of your statement. That's page 7, if you want to have those paragraphs to hand. We have already looked in an email in which the issue of remote access was raised in April 2014, and that was the email from Steve Darlington, dated the 8th of April. Could we have that back on screen, please? It's POL 001 48049. You'll recall, because we read the email out earlier, but if we can scroll down, please, to the bottom email in this chain so we can have it there. That's it. The Dear Ron, 8th of April 2014 email. This was the email which raised an email between Andy Wynne and Alan Lusher in a case called Ward, which was said to explicitly state that Fujitsu could remotely change the figures in branch without a sub-postmaster's knowledge or authority. And this prompted Mr. Warmington to propose this email, which also addressed the Helen Rose report, for discussion at the working group weekly meeting. Bottom of page 2 of this document, please. We see your email. And it's the first sentence or paragraph here. And you ask if anyone knows anything about the email being quoted below about remote alteration of figures in branch. And you say, I think that this is a new one on me. Was that new to you at this point then, the issue of remote access? Or was the thing that was new this particular email?
I think the thing that was new was this particular email. My previous knowledge of the issues relating to remote access, as far as I recall, was specifically in relation to Spot Review 5, concerning a team at Bracknell which allegedly were altering transaction data without the knowledge of sub-postmasters. I think I'm paraphrasing there. And this was an issue that cropped up on a number of occasions during my involvement with the scheme, and that was the lens through which I think I viewed everything relating to remote access.
Going to the top of page 1, please. This is your email of the 14th of April 2014. And 3 lines in, you say there are a few questions we need to answer, I think. And this is in the context of the email. Andy Parsons was going to speak to Andy Wynne about it in the sentence above. And you say there are a few questions we need to answer, I think. 1, what is the explanation? 2, has this statement been used publicly, in court or otherwise? 3, have the contents of this email been disclosed, either A, through the criminal disclosure process, or B, to Second Sight through responses to spot reviews, or C, as part of one of our investigations, or D, to second sight in other miscellaneous material we have provided in the past. 4, if this email has not been disclosed publicly, regardless of what our response is, we need to consider how it came into Howe & Co.'s possession. Can you help, having posed these questions, with what further involvement in this particular issue you had, if any?
So, looking at the documents that have been provided to me, on a couple of occasions between then and me leaving the post office, issues relating to this arose, and I'm not able to see from the documents, and I have no recollection of any continuing process. But in relation, but to try and address it through the lens of how things worked at the time, this would have been me having been sent something and trying to do some sort of analysis of what the key issues might be, so that Andy Parsons could create a brief for Chris Orjard so that he could have a conversation at the working group. And however unsatisfactory that might now feel to me, and also seem now, a lot of my role was trying to pull things together to make sure that people could answer the questions they needed to. So I engaged, I'm afraid, more with the process than the detail. I don't remember checking the brief. I don't remember seeing the brief that Andy would have done. And I don't remember any other activity specifically relating to this.
Could we have on screen, please, POL 30091394? The first email in the chain starts towards the bottom of the page and is from Jessica Barker, dated the 13th of October 2014. And she forwards on to you, among a number of others, revised draft CRR in a case that was being looked at by the scheme. The timings of this email chain are a little confusing because your email above Jessica Barker's is 11:46, and your email above of the same date is 10:59. So I'm not sure what's going on with the date stamps there, but your email above appears to be a reply to Jessica Barker's email. Does that look right to you? If we look at Jessica Barker's email, scrolling down, we have, Dear all, Second Sight have released a revised version of their draft CRR for case M053. Some background to this: you will remember that Second Sight originally uploaded a draft CRR some weeks ago. They've produced a new draft CRR, and then just explains what's attached to the email and what the deadline for responses is. Going further up, please, to your email above, which would appear, would you agree, to be a reply to Jessica Barker's email. It says, is this the first which references remote access, ?
Yes.
I think we need to pick this up very robustly in our response, as this could become public, and Second Sight seem to be asking for proof that something didn't happen. And you say, Mel, could we dust off our lines on this, as this will be with the applicant and advisor tomorrow?
Yes.
So you seem to have been aware of there being lines to take on remote access before this, is that right?
Yes.
Yeah. The lines to take that you had in mind Where had they originated from?
I don't recall.
Melanie Caulfield responds above the same day as follows. Our current line, if we are asked about remote access potentially being used to change branch data /transactions, is simply, this is not and has never been possible. This line holds, but if we are pressed regarding a second site's points about admitting there is remote access, etc., we can say there is no remote access for individual branch transactions. We might get pushed further on it and be asked by media to confirm whether or not there is any remote access. We will need to make the distinction re-access as straightforward as we can, so suggest there is no remote access for individual branch transactions. Fujitsu has support access to the back end of the system used for software updates and maintenance. This is, of course, strictly controlled with security processes in place, but could not in any event be used for individual branch transactions. There is no facility at all within the system for this. And then Melanie Caulfield says, I'll get a view from Fujitsu comms, but let me have any comments. Did the existing line being, this is not and has not ever been possible, trouble you at all on reading this email? Given that what follows seems to be alternative, more fulsome lines.
So I think it depends on the question being asked. So if I could address that by way of what I picked up in the, I think it was the second bundle of documents that were sent to me by the inquiry. In October, I think I was starting to get a little bit confused and maybe concerned about the way that the issue of remote access was being defined and therefore being answered. And in fact, that was one of the amendments to my statement, that I thought a wider piece of work needed to be done. I can't now remember the exact terminology, but to identify what the specific questions were and then what the answers were, because I think many of us had in our minds something different when we were answering the questions, and I wasn't sure that we were turning our minds specifically to what the point that needed to be addressed was, and therefore giving the correct answer.
Could we have on screen, please, POL 001 49276? Going, please, to the first email in this chain, which is towards the bottom of page 1. The email from Melanie Caulfield to Andrew Parsons and Jessica Barker, dated the 17th of October 2014. And the subject is remote access, reactive statement in strictest confidence. And it reads, hi both, a quick update because Fujitsu comms have come back with revised wording. I think they have made our statement stronger, so that is good, but I suspect because there is, of course, some remote access so that the system can be maintained, etc., second site will continue to pursue. And then there are some lines underneath that. If we're asked about remote access potentially being used to change branch transactions, it is simply the system is designed to prevent any access, either remote or direct, that would allow individual branch transactions to be altered. If pressed further, the system has been designed to prevent any access, either remote or direct, that would allow individual branch transactions to be altered. Fujitsu has controlled access to the Horizon system for software updates and maintenance purposes. This is, of course, strictly controlled with security processes in place, but could not in any event be used to alter individual branch transactions. There is no facility within the system for this. As far as you can remember, was this email prompted by the particular case discussed in the 13th of October email chain that we've just looked at?
I don't know.
Going then to the reply from Andrew Parsons above, dated the 19th of October, 2014. Mr. Parsons says, Mel, I'm just about comfortable with this. I understand that although Fujitsu cannot alter individual branch transactions, they can inject a transaction into a branch's accounts, brackets, through use of this facility, though use of this facility is very, very rare. So we just need to keep being careful with any changes to the wording below until we get to the bottom of this. This email is then forwarded to you, Patrick Bourke, and one other by Melanie Caulfield. And the email simply says, so this is the first point at which you enter the email chain at the top, and it simply says, as discussed. Can you recall discussions around this at the time?
No.
This reactive statement, can you recall whether it was for use for a particular case, whether the M053 case or another, or more widely?
I can't recall, and I don't remember the case, and I probably didn't read the case. I think it would have been for wider use, and I think it might have been if a question was asked in relation to remote access on the back of the release of a case report to an applicant, the applicant or anybody associated with that applicant might have spoken to the press about it if they thought it was significant, therefore having a position in relation to wider application.
It seems that after this email, you were then sent further information from Fujitsu. Could we have on screen, please, POL 003 49472? In the middle of the first page, we have an email from you dated the 20th of October 2014, and you are responding to James Davidson's email of the same date, which starts at the bottom of this page.
Yes.
And if we can go over the page, please. We have this. Belinda, I found the response to Rod's note. Happy to discuss further, let me know. And then there are some answers in the email below. Just scrolling slowly down, please. Which appear to have been provided in response to questions put by Roderick Williams in April of that year. Is that right?
Yes.
And a summary is provided of Fujitsu's response. And the summary is, there is no ability to delete or change records a branch creates in either Old Horizon or Horizon Online. Transactions in both systems are created in a secure and auditable way to assure integrity and have either a checksum, brackets Old Horizon, or a digital signature, brackets Horizon Online, are time-stamped, have a unique sequential number, and are securely stored via the core audit process in the audit vault. The second point, whilst a facility exists to inject additional transactions, in the event of a system error, these transactions would have a signature that is unique. Sub-postmaster IDs are not used, and the audit log would house a record of these. As above, this does not delete or amend original transactions, but creates a new and additional transactions. Third point, this facility is built into the system to enable corrections to be made if a system error /bug is identified and the master database needs updating as a result. This is not a unique feature of Horizon. Fourth, approvals to inject new transactions are governed by the change process, two-factor authentications, and a 4 eyes process. A unique identifier is created and can be audited for this type of transaction. Within HNGX, Horizon would require more extensive work to investigate, as explained below. Going back then to your comments on this on the first page, and it's about halfway down there.
Yes.
And this may be the email you were referring to
I think it
earlier,
is.
when you said for information, sending this on to Melanie Caulfield, Patrick Bourke, Angela van der Bogert, and Tom Weschler. This is F. Fujitsu's response to a series of questions about what we are now, in my view, incorrectly badging remote access. As we have discussed today, we need to set out in more detail what the position is and is not in relation to what can and cannot be done to Horizon data, by whom and under what circumstances. I will set something up to this effect with Fujitsu and others. Were you aware at the time you were writing this email, so in October 2014, that Deloitte had produced a draft report for discussion in May of that year, addressing, among other things, remote access? And that's the report dated the 23rd of May 2014, which I think you were provided a copy of when you made your statement.
Yes, that would be under the heading of Project Zebra.
Yes, that's correct.
So I was aware of Deloitte being commissioned to provide a report for the CIO at the request of the board. Yes, as I recall. I have no recollection of it specifically addressing remote access or Deloitte being instructed to consider the matter of remote access. So I didn't make the link between this and that report.
Moving to November 2014, please. Could we have on screen POL 001 42406? Starting, please, with the top of page 2 of this document. There is an email from James Davidson to you, dated the 12th of November 2014. And it's copied to 2 others. This subject is March 2010 incident details. And Mr. Davidson provides details about an incident from that date. This was a document which was sent to you by the inquiry at the time you were asked for a statement.
Yes.
Have you had a chance to read through it?
Yes.
I'll take it relatively quickly, therefore, but please do say if you want me to slow down or you want to go back to anything.
Yes.
The problem experienced by a sub-postmaster was a duplicate transaction being generated when the system went offline unexpectedly. And that's the first paragraph there under background. The sub-postmaster spotted it and called the helpline for assistance. We can see in the timeline the accounts were repaired by the insertion of auditable records into the branch database to negate the duplicate transaction. The fix was approved by the Post Office, and in this instance, the sub-postmaster was also told. So we can see underneath there, approved by Post Office Ltd, sub-postmaster informed. But would you agree, having read this summary of events, that this insertion could have been conducted without the sub-postmaster knowing about it or approving it?
That wasn't the way that I had subsequently read it, so I don't recall it from the time. Although I do now recall that that one incident had arisen, but I hadn't interpreted it the way that you are describing it. Reviewing it now, what I have taken from it is that this was a system or a change to a system that was being piloted in a small number of offices, and a sub-postmaster had noticed an issue. Therefore, the sub-postmaster was aware, and the sub-postmaster's accounts were corrected with the agreement and with the visibility of the sub-postmaster. And as it was a pilot, there were arrangements in place to fix the issue, which I have assumed meant that before the system was rolled out, that the matter was resolved, and indeed the pilot had successfully identified possibly more issues, but successfully identified and rectified this issue.
It is fortunate, isn't it, that the sub-postmaster spotted the duplicate transaction in the first place, because if he hadn't and he'd had problems balancing, might this not just have been another unexplained shortfall case?
I can see theoretically that might have been the case. I didn't think of it in that way, but I accept that it could have been the case. What I'm not clear about, because I've never even seen a Horizon screen, I don't know how obvious such an issue would have been. So I accept that if the sub-postmaster is part of a pilot, they would probably be more alert and more diligent in terms of spotting things, because that would be part of the reason for a pilot. But I hadn't viewed it in the way that you describe it.
Looking then to your response to this email at the bottom of page 1, please. So you forward this on the 12th of November 2014 to Patrick Bourke and Mark Underwood, copied to Andrew Parsons. And you say, details of the transaction inserted by Fujitsu. Mark, could you please check the branch against applications in the scheme? And then going to the top of the page, please, still the 12th of November 2014. Mark Underwood replies and says this: "Hi all, I'm extremely pleased to say it does not relate to any of the branches in the scheme. For information, below is the affected branch." Why did you understand Mark Underwood to be extremely pleased that this was not a scheme case?
I can't say that I understood it at all. I can understand why I would have asked him or somebody to look to see if it was a case in the scheme. And in view of the fact that this issue had been identified, then I think we would have wanted to assure ourselves that it was properly explained in any post office response to the scheme, and I would imagine that was my reason. I don't want to assume what Mark might have thought by trying to second guess what was in his mind when he wrote that.
Did you feel any relief that the incident did not relate to any of the branches in the scheme at the time?
I'm not sure that I had any feeling about it whatsoever, insofar as I had been reassured, I think, having bearing in mind the previous emails which talked about the possibility of transactions being inserted, which was something I had not turned my mind to. The fact that it appears to have happened once, and that was during a pilot exercise, and the issue had been identified and rectified, I think I was reassured rather than anything. But I would have been concerned had this case been in the scheme and this issue had not been correctly articulated. So in that respect, I suppose I would have been pleased.
Could we have on screen, please, paragraph 20 of Ms. Cortes-Martin's statement, please? That's page 7. Towards the bottom of that page. You say here at paragraph 20, the issue of remote access was raised by Second Sight on a number of occasions during my time on the scheme, but my understanding was that Post Office Ltd considered that the matter had been addressed in response to Spot Review 5, and as far as I was aware, Post Office Ltd and Fujitsu maintained the position that transaction data could not be changed remotely without the knowledge of a sub-postmaster. Is that an accurate description of your understanding at the time, notwithstanding that November 2014 email?
Yes, I think it is. For me, it's rather like a number of the other issues. I was reassured by people I spoke to that this issue arose as a result of Mr. Rudkin's visit to Bracknell. And again, I understand now, with the benefit of hindsight and knowing what I now know, that this was a far more significant and broader issue. And I viewed everything through that lens. The issue was whether or not transaction data could be changed remotely without the knowledge of a sub-postmaster. And on the face of it, that was my understanding, and that continued to be my understanding.
I'd like to move, please, to Second Sight's role and how this was managed by those involved in Project Sparrow.
Yeah.
The statement can come, actually, if we can keep the statement on screen, please, and go to page 4 of it. At paragraph 10, you say, although my job title was Programme Director, it became clear early on that I did not have any strategic responsibility or any final authority to make decisions in relation to the scheme, and whilst I managed a small team of colleagues carrying out work in relation to the scheme, I did not supervise or manage any other persons in managerial positions. Myself and my team were very much coordinators as opposed to decision makers, carrying out the instructions and requirements of the scheme working group in my capacity as Secretariat, the board, its subcommittee, and Post Office Ltd General Counsel. Should we take it from this that you consider your role as Programme Director of Project Sparrow was mistitled?
Yes. Sorry, can I clarify? I think in the first instance, we established a programme board, and I think that the title at that stage was correct. Some of the documentation that I have seen, and from my recollection, I would have said a programme director or maybe a programme manager or a project manager, but I think that would have been more accurate. Subsequently, the the governance for this not the scheme, but the entirety of the work that would have fallen within the programme changed, specifically when the board set up a subcommittee. And I think by that time the steering group had ceased to meet, I think. But trying to run a programme board, with a very small team to support a programme board, a subcommittee of the board and the working group was far too much governance, and so the programme board ceased to exist. As far as I can see, it didn't meet after April. So I think somewhere between maybe February and April, it had become clear to me that this wasn't a programme director role in the normal sorts of event, in the normal scheme of things. So in that respect, I think that is correct.
You say at paragraph 31 of your statement that Paula Venables chaired a steering group which oversaw the work of Project Sparrow. Did you ever raise your lack of strategic responsibility or final authority to make decisions with Paula Venables at all? Was it something you were dissatisfied with?
No, it wasn't something that I was dissatisfied with. My recollection is that Paula somebody had asked me to provide the secretariat to the working group. So that was the email of the 8th of October. Then, and you've referred me to it during this session. In November, there was a meeting of the steering board, and actually Paula announced at that meeting that I would be the programme director for Sparrow. I do not recall having had any conversation with anybody about that prior to that meeting. I don't want to, or I'm reluctant to attribute anything to anybody else, but I think Angela might have been as surprised as I was by that announcement. I did not challenge that announcement, but I wasn't disappointed or concerned when later it transpired that I would have been doing primarily what I had anticipated in the first place, and that is running the scheme and supporting the scheme.
Moving please to paragraph 30 of the statement, that's page 17. You say, in terms of Project Sparrow, I am not aware of the background to its setup, as this was before my involvement in the scheme. I do not recall if I was ever told its original remit. Once you became Programme Director for Project Sparrow, did you seek to further understand the project's genesis at all?
No, I can't say I did. What I was more concerned about was trying to define what it might be going forward. Because, and I think this, if you like, summarises where I started on this, and that was that Second Sight report had published in August.
July, I think.
July. And the scheme and Post Office's response to that had published in August, and therefore my understanding was a line had been drawn under pretty much what went before, and therefore I didn't concern myself too much with what had happened in the past. I was just looking at how things might be managed going forward.
And on that, could we have on screen, please, POL 3030694? This is a document entitled Project Sparrow. And going to the second page, please, we can see about halfway down the page the initials BC. Are they your initials?
They are, yes.
And the date, the 13th of November 2013.
Yes.
So relatively shortly after you started in the roles, but before the fixed term contract started in January.
And before I took over the role officially.
Is this a document which you authored?
I think so, yes.
And going back to page 1, please. We can see there the first heading is scope. You mentioned before your concern being what Project Sparrow would be going forwards. Was this you setting out your idea of what it would be or what it was?
Yes, I think so. Yes.
There are said to be 4 work streams falling within the scope of the project. There are, in fact, 6 main bullet points, but just looking to just the headings under there for the work streams: the mediation process and working group, the review of criminal cases, brackets completed, disclosure, development and implementation of intervention prosecutions policy, including potential permanent complaints handling arrangements, final report for closure of the project and the issue to enable return to BAU, is that business as usual?
Yes.
And then finally, targeted business improvements strictly limited to those parts of the processes which are specifically linked to the scheme. Just picking up on the review of criminal cases.
Yes.
Was your understanding of what the review referred to here was?
That that Post Office had an enduring responsibility in relation to its prosecutions, an enduring responsibility of disclosure, I think was the terminology as I understood it, and therefore any issues that arose as a result of investigation into complaints on the scheme had to be considered in terms of whether or not any disclosure was required. There were a team of people, or there were some people doing that in Cartwright King, and that was an ongoing piece of work.
You've put in brackets here completed. So was that your understanding, that the review of criminal cases was complete?
Oh, so the review of criminal cases, yes.
Going then to success criteria further down the page, please. At the 4th bullet point, and I should say directly under the success criteria, we have a by the end of April as a goal. And the 4th bullet point, second site involvement, will have ended with Post Office re-established as credible investigators of complaints, bracket endorsed by second site, political support for completion of second site involvement, and third, JFSA neutral position on SS involvement. Did this reflect a view of the Post Office that second site's involvement after the interim report should be limited to involvement in concluding the scheme, rather than any further investigation or reporting on the Horizon system itself?
Yes, if I'm understanding your question correctly, my understanding was that the view within Post Office was that second site's role changed following the publication of its report into one of reviewing investigation reports on complaints in the scheme.
And where did your understanding on that come from?
I really couldn't say. I think looking at the timing of this document, I must have spoken to a number of people that had been involved to inform what it might look like. And therefore, that is something I would have picked up. I see from the bundle of documents that I have been provided with that there was a reference, I think, made by Andy Parsons about a decision had already been made to remove Second Sight from the process, but I don't think I ever found out where that originated. It seemed to have come from a conversation between Susan Crichton and Second Sight, but by this time Susan Crichton, if she hadn't actually left, she was not in the office very much. So I don't think I ever got to the bottom of that. But I think looking at the timescale here, this was, as it turns out, a hugely optimistic timescale. That by the end of April, the scheme would have completed. And therefore, with the completion of the scheme, future investigations would be carried out by Post Office, and Second Sight wouldn't be required to review them. So we would be into business as usual.
The last bullet point on this page says new investigation /intervention /enforcement /prosecutions arrangements in place, announced possibly in the final report and operating fully, potentially includes investigation arrangements, intervention arrangements, prosecutions policy, and permanent appeals /mediation scheme. Did you understand it to be a Post Office priority to re-establish prosecutions of sub-postmasters and others working in branch?
No, I didn't. I think my understanding is that prosecutions had ceased before I became involved in the scheme, and there, certainly from the point of view of General Counsel, there didn't seem to be any rush to start them again until this whole process had been completed. But that was just a perception. I couldn't tell you where that came from, but certainly I didn't. If there were any pressure to restart them, it would not have been exerted on me, and I was not aware of it.
We saw in Paula Vennell's email announcing the roles you would be taking on, and that was in October 2013, that you had been asked to help coordinate a short internal lessons learned exercise
Yes.
on the process leading up to the publication of the interim Second Sight report. It appears that you, from the documents, that you reported to the Audit, Risk and Compliance Subcommittee on this on the 15th of May 2014. Could we have those minutes on screen, please? The reference is POL 000 21426. We see here the minutes, 15th of May 2014, and in attendance is your name is there, Programme Director, Project Sparrow, brackets minute, POL ARC 1423 only. And then going to page 4, please. About 2/3 of the way down the page, we see a heading, Project Sparrow, with that reference on the left there. And Belinda Crowe joined the meeting. So you were joining the meeting just for this specific item, is that right?
Yes.
And then this at B, the committee received a report on lessons learned from the handling of the commissioning of the second site investigation into Horizon and subsequent events. Do you recall delivering this report now?
Yes.
Casting your mind back, what were you told about why you were looking into lessons learned from this?
So I think I alluded to this earlier. It was quite tricky because I had felt that I was being asked to. I felt in the first instance I was being asked to look at whether or not someone was to blame for the fact that there was some confusion about the establishment of the scheme. The reason that I'm vague about it is because at the heart of this, and I'm choosing my words carefully because I don't know the circumstances, which is actually relevant here. At the heart of this was the departure of Susan Crichton. And what I was keen not to get involved in is to get involved in any sort of apportionment of blame in relation to what might have led to her departure. Not only because I wouldn't have been prepared to do that, but because I didn't know what led to her departure. My working assumption was that the decision to appoint Second Sight and undertake an investigation, and then at the end of the report, the decision to announce the establishment of a mediation scheme and the involvement of JFSA and Second Sight was felt to be decisions made by Paula and Alice with MPs as opposed to necessarily engaging the wider business. That was what I understood to be at the heart of this. And then subsequently, and this is the issue that I think I focused on, which I think is explained in the minutes here, subsequently, almost having made an announcement, because it was expedient to make an announcement, the Post Office then wasn't geared up to actually accommodating that announcement. Therefore, to announce the establishment of a scheme without the people in place to support that scheme, or having worked through the detail of that scheme, seemed to be creating a problem in the business. So insofar as I can recall, and I haven't been provided with my paper, but I think it was a very short paper, avoiding any attribution of blame, because I didn't consider that was my role, but to talk about the importance of engaging the business in business decisions and the importance of the business being able to respond in a way that was fleet of foot to anything that it wanted to do quickly.
And is that what we see here at C in this summary given in the minutes? It was noted that there was a need for a formal protocol for enterprise-wide response to enable the business to respond quickly and effectively to any crisis, high-risk or high-profile issue. The committee also discussed whether there was a need for an identified in-house team ready to deal with such issues.
That's at the heart of it, and I think that was the only thing I could sensibly recommend.
And at D, we see it was agreed, it was agreed by the committee. It was agreed that establishing such a team or teams would be sensible action, and that appropriate oversight by the CEO and or the board was important. The committee also suggested that scenario planning should be considered and a virtual crisis management team and support, lawyers, accountants, internal and external resources be put together. So was that a subparagraph D, was that the discussion, recording the discussions that were had at the meeting as opposed to your report? or was
That
it both?
that was recording the discussions at the meeting, flowing from, I think, a discussion of my report, because I think that was, insofar as I can remember, I think that was a key feature, the ability to respond to issues quickly.
Why was it that an in-house team seemed to be sensible to those in the discussion as opposed to an external team?
I don't know. I really don't know. I think so if it had been the ability to pull together a small team, such as the small team that I worked with to deal with these issues, that would have been primarily in-house. I don't recall the discussion. I don't know that anything significant arose in the course of the discussion which said it had to be in-house. What I would say that Post Office relied heavily on externals.
That document can come down now. So I wonder if that's a convenient moment for the second morning break.
Yeah.
Thank you. Is it 1:15 by my clock, which would take us to 25 past?
All right, fine.
Thank you, sir. Hello, sir. Is the connection working as it should still?
Yeah, yes, it is. Thank you.
Ms. Cortes-Martin, you've already referred to your understanding of the Post Office's position that Second Sight's role changed after the publication of its interim report. Would you agree that there should have been an engagement letter clearly setting out Second Sight's role and responsibilities in relation to the scheme from the very get-go?
I would.
It may be that you've already given your answer to the chair on this in response to different questions, but what is your understanding as to why this wasn't done? I appreciate it was before you started properly in the role.
Well, I think it was because, and maybe this links to the lessons learned piece, and that was that there was a desire to follow up Second Sight's report with an announcement very quickly. And again, I'm speculating and going on what my perception is rather than any hard facts. And therefore, it was my view that not enough thought had gone into how this whole thing might work going forward, which meant that I felt we were almost, if you'll forgive the terminology, retrofitting some stuff, and this was one such issue. I have no idea whether or not anyone had a conversation with Second Sight about this and the engagement letter was not seen as necessary, or whether or not Second Sight's view changed. I have no idea of the reason, but why there were differing views. But I think there was a haste in announcing the scheme and some components of it, which meant that some of the basics weren't done.
As Programme Director of Project Sparrow, what was your understanding of Second Sight's mandate throughout the period you held the role?
It was to produce, and the terminology might have changed as following Sir Anthony Hooper's arrival and the scheme developing, which it did, but it was primarily to review Post Office's investigations into the complaints and support the working group in whichever way the working group wanted support from Second Sight. So I think those were the two facets of Second Sight's engagement.
You say at the start of paragraph 58 of your statement, and we can go to it if that would help.
Thank you.
That's page 28 of the statement, please. At the start of paragraph 58, I have been asked if I at all considered there to be a difference between what Post Office Ltd stated publicly about the mediation scheme compared to what was discussed internally. I do not recall thinking that there was a difference. However, I do think that it became clear once the scheme got underway that Post Office Ltd's view of Second Sight's role and how the scheme would work differed from others' views, such as JFSA and Second Sight. So on this point about you not recalling a difference between what was being stated publicly about the scheme and what was discussed internally, could we have on screen, please, POL 00116285? This top email is from Chris Ojard, dated the 23rd of February 2014, and is providing comments in red on an email originally sent by Paula Venables to you, Chris Ojard, and Angela Vanden Bogert, among others, on the 21st of February 2014. So if we can just scroll up a little, please. We can see there the 21st of February email from Paula Venables to you and those others that I've just mentioned.
Mm-hmm.
Going please to page 2 and point 3.6. And so the text in red is that applied by Chris Ojard. The text in black is from Paula Venables. And at 3.6 it reads, potential cost, and this is of the scheme, 10 million plus serious. When we went into this, the motivation, brackets Alice and me, was to find out what was really going on, to create so much noise, and to put in place processes that we felt were closer to the way we wanted Post Office to be run, brackets more supportive, going forwards. The system that was in place at the time was when we were a division of Royal Mail and accountable to their legal and security directors. Sparrow was our opportunity to reset the dial for Post Office as a standalone business. We did not intend it to result in major compensation for policies that were followed and applied to thousands of others who did not have problems and which were operating in a different corporate context. We seem to have lost this focus, and I'm looking for advice on how we regain it. It should be part of the second site TH pre-meet in Monday and will be a question from the board, brackets Chris, Mark, Belinda. What did you understand the message to be coming from Paula Venables in this email about the level of compensation that she and Alice Perkins envisaged being paid to sub-postmasters at the outset?
That it was much lower than Post Office, I think, informed by, I think, some Bond Dickinson, or if not some PA consulting analysis, were suggesting on the basis of having looked at some of the early allegations and case questionnaires.
What did you understand Paula Venables to be seeking from you and others in terms of a steer on what to do about her concerns? What was she asking for advice on?
So I'm not overly clear on this, but a couple of things spring to mind. And one is, and this cropped up on a number of occasions, and indeed I think was a comment made by CEDA, that, that was the mediation company that were assisting us with mediations, that this was established to be a mediation scheme and not a compensation scheme. And yet, I think already Paula and the board were concerned that this was viewed as a compensation scheme. So that was one point. And the other, I think, what she was trying to do was to ask how we could get what seemed to her to be a system that was getting out of control back in control. Sorry, that's a rather vague answer, but that's the way it's reading to me.
Did you give any advice in response to that paragraph in particular?
I don't recall. I may have done. I don't recall.
Does sight of that paragraph change the paragraph in your statement we've just looked to in any way as to the difference between discussions internally and what was being said publicly about the scheme or not?
I don't think it does, because I think this is what Paul is saying, is the original intention of the scheme as she envisaged it, or she and Alice envisaged it, therefore presumably as announced, is changing. So actually maybe the opposite is true, that she is saying that what is happening in reality is slightly different to what the original intention was, which I think is why I did not feel that there was a difference between what was being said internally or externally.
That document can come down now, thank you. Going back to Second Sight's role and attempts to put in place a letter of engagement in 2014, could we have on screen, please, POL 001 47169? Starting, please, with page 2 towards the bottom. We're looking for the 10th of January 2014 email, 10th of January, from Ian Henderson to Chris Ojard, copied to Ron Warmington and to you. And the subject is proposed engagement letter. And this is an email forwarding another email discussing the terms of Second Sight's engagement letter. And the original email is on page 3, please, about halfway down. It is from Ian Henderson, and it is the 6th of January 2014. Originally to Christopher Ojard and copied to Ron Warmington. Going to page 4, please. Under point 7, Mr. Henderson wrote, the proposed scope of services schedule raises a number of issues that are at variance with assurances previously provided by Post Office Ltd to both Second Sight and to the Right Honourable James Arbuthnot MP. In particular, the scope of services schedule attacks the fundamental principle that Second Sight operates completely independently of Post Office Ltd and conducts its investigations and prepares reports as it sees fit. So just stopping there, if we can go back to page 2, please, and to your email of the 10th of January 2014. And you request a meeting. So Ian, Chris has discussed this with me, and I understand you and he have spoken. Would it be possible for us to meet on Wednesday morning next week to discuss the engagement letter? We think possibly face-to-face is better if that works for you and Ron. And then going, please, to the top of this page. Of page 1, forgive me. And so you forwarded this email thread to Andrew Parsons on the 12th of January 2014. And you say, I have made some comments in caps to the points SS have made, so points in capital letters. And can we go to one of the comments, please, on page 4? And so the comments made by Mr. Henderson that aren't in capitals, your response to, are we right to see the capital letters there as being your response to what he's saying?
I think so, yes.
And you write, we need to consider carefully what and how we seek to fetter. SAH,
Sir Anthony Hooper,
has made it clear that Second Sight can include what it wants, so we need to tread carefully. What did you mean when you said we need to consider carefully what and how we seek to fetter?
So first of all, I've been sent several copies of the draft engagement letter, and I can't guarantee I've related the exact one to the exact email. So I'm speaking in the abstract here. First of all, I would say that the commenting in this way, one doesn't necessarily expect that some 10 years later you're going to be asking questions about it. So I acknowledge that in this and other emails, I have not chosen my words as I might have done had I known this. But I think what I'm saying here is there must be something that Second Sight has objected to that makes it look as though Post Office is trying to fetter it. And what I'm saying is we need to think carefully about the extent to which we do that. And actually, it's nothing more than that. So don't try to fetter Second Sight in a way that's not appropriate, particularly in light of what Sir Anthony Hooper has said. I realise, looking at it now, it's not worded particularly well, but I think that was all I was trying to. That's all I was trying to do. I think what Post Office were trying to do was to tread a line between trying to do what clearly Paula and the board wanted, and that was to keep the focus for the scheme without getting into any difficulty about making it look as though Second Sight's independence was being fettered in any way.
Could we have on screen, please, POL 001-99572? This is an email chain dated the 13th of January 2014 involving Alan Bates, Paula Venables, you and others regarding the scope of Second Sight's engagement. And the initial email in the chain is on page 2, please. And this is from Mr. Bates, and he wrote as follows: to Paula Venables, 13th of January 2014, subject concerns. Hello, Paula. I am quite concerned about what I have been hearing recently about Post Office Ltd trying to change the scope of the scheme in order to restrict the terms of the investigation and stop certain matters being discussed. I should make it clear that JFSA signed up to the details as were discussed and documented last July, August, and alterations to what was agreed will result in JFSA withdrawing from the working group in the scheme. I do not know if you're aware of what is being proposed by the new Post Office Ltd members of the working group, but from what I can glean, it seems as if Post Office Ltd are trying to hijack the process, which is something your minister assured me would not happen in her letter to me last September. I would be grateful if you would look into what is happening at present. The impression I am getting seems very different to the discussions we had last year. Going please to the top of the chain, page 1. This is an email sent by Sophie Bialuski.
I'm sorry, I never get it right myself.
Dated again the 13th of January 2014. And we can see her role at the bottom of her email was Public Affairs Manager for the Post Office. And she says, so this is sent to Mark Davies and Nina Arnott. She says, thanks, Mark. Had a quick chat with Belinda, who has picked up with Second Sight. Let's all keep each other up to date with any news. This email came through the day after the email we've just looked at, your email to Mr. Parsons with the reference to the fettering and the concern about that. Was there anything in what Mr. Bates was saying that the Post Office was trying to hijack the process, from your perspective?
I hadn't made the link. I don't know if I made the link at the time. I didn't make the link when reading these documents. But could we just scroll down to Alan's comments, please?
That's page 2.
Right. Right. So when I first read this, I thought this related to something that had been discussed at a working group meeting, but that's not actually what Alan is saying.
Well, what was the issue that was discussed at the working?
I can't recall. Sorry, what I meant was that I thought Alan, because Alan did on a couple of occasions write about concerns about the working group and discussions at the working group, but looking at it again, that's not exactly what he was saying. The reality is, I don't know, but in view of the fact that I spoke to Second Sight, there is a distinct possibility that Second Sight had spoken to JFSA and said that the terms of engagement seemed to be limiting, and therefore I spoke to Second Sight about it. But I'm speculating here. I just can't recall.
As far as you're aware, was the Post Office restricting the terms of the investigation?
So, because my understanding also always has been that the role of Second Sight was to focus on the cases in the scheme, then the answer to that is no. And I think I say in my statement that there is clearly, and it became apparent throughout the process, that there were differing views on the role of Second Sight, but I can't recall that Post Office's view ever changed, and I'm not sure that any of the original documentation suggested that Second Sight's role was wider than the cases in the scheme itself. I haven't subsequently gone back and checked, so I could be wrong in that.
Could we have on screen, please, POL 30298813? This is an email dated the 1st of February 2015 from Roderick Williams to you and other Post Office employees. He explains that he is providing his comments on the difficult questions (boxes) document, and the subject line in the email is narrative boxes RW comments on the difficult questions boxes document. Can you help, first of all, with what the difficult questions boxes document was?
I don't know, but looking at the timing, this may have been to do with the questions and answers that were being drafted for Paula for her appearance before the Select Committee. But that is just from looking at the timing, that's the only thing I could think it might be.
On page 2 of this document, point 8, there is a section on Second Sight. And at the third bullet point here, there is this: re-fettering, in quote marks, SS independence / challenging SS's findings. This demonstrates their independence. Second Sight make findings and recommendations, not, in capitals, decisions. Post Office has always retained that power. Did you agree with Mr. Williams' comments in relation to this? That Post Office has always had the power of decision?
So it's difficult to answer in the abstract because I don't know the contents of the boxes. But I don't know that Second Sight had any decision-making power in relation to the working group or the cases. Does that answer your question?
It does. And in relation to the reference to fettering, which is in quote marks then, can you help at all with where that comes from? It may be that you can't if you don't have the underlying.
I can't, apart from to say that I think it was a term, so I don't think I introduced the term, but I think it's like many of the terms that we use. It was sort of shorthand for, is Post Office trying to control second sites? But again, I'm trying to answer in the abstract here, and I don't think I can do that helpfully.
I'd like to turn, please, to your involvement in the substance of complaints in the scheme, or absence of involvement. You say at paragraph 30, apologies, that document can come down before we turn to the new topic. You say at paragraph 33 of your statement, and would you like to look at that? That's
Please, yes.
page 17 of the statement, please, paragraph 33. You say here, nevertheless, whilst investigations into complaints contained in scheme applications technically fell within the scheme, I was not responsible for the substance of those investigations. Angela was responsible for this work because of her particular expertise and experience in Horizon and the way the system worked, and she managed the investigation team. My involvement in investigations was limited to chasing the progress of those investigations, along with progress of Second Sight's reviews of the investigations, in order to effectively manage the progress of applications within the scheme. Could we have on screen, please, with that in mind, POL 30099694. This is an email chain from October 2013, so very early on. And the original email in this chain is from Ron Warmington to Paula Venables, and it starts at the bottom of page 1. We can see the subject is example applications there. To Paula Venables, copied to Angela Vanden Bogard. And he's sending there 8 examples of the incoming applications, presumably incoming applications for the scheme.
I assume so.
Going then to the middle of page 1. We can see Paula Venables forwards Mr. Warmington's email onto Martin Edwards, you and Mark Davies. And she says this in her covering email. So this is Wednesday, the 2nd of October. Dear all, I'm not sure who else I want to read these yet, but certainly the 3 of you. They make disturbing reading. Brackets, I couldn't make sense of the spreadsheet, but the individual submissions are sufficient to get a steer on what we are dealing with. We have to keep it in perspective, of course, but even in perspective, they are challenging from all sorts of angles. Brackets, Belinda, these are examples of Sparrow cases that have been submitted for consideration for mediation. I'm with Angela tomorrow AM. She and her team are hopefully going to talk me through where we have made improvements and where we still need to do more. I am glad I've decided to make the trip. We need to show we are taking this very seriously. Was Miss Fennells seeking your views on the substance of these complaints by this email?
I can't imagine that she would have been. So, looking at the timing of this, I think my involvement in the scheme had not been announced. I'm certain it wouldn't have been. Sorry, I'm as certain as I can be, because I think that was the following week, 8th of October. But I think she was just giving me some information in relation to the scheme that I was going to be involved in. I don't think she had any expectation that I would be either commenting on or involved in the detail. What I would say is, I think this is the email I referred to earlier, where I asked to see a copy of the report.
If we can go up and have a look at that now. So your response is at the top. And this is the 3rd of October from you to Paula Venables, Martin
Yes.
Edwards, Mark Davies. Thanks, Paula. Not easy to read on BlackBerry, but I see your point from what I can see. I have not seen the second site report. Would someone be able to send me a copy? I hope to catch up with Angela after you have seen her today. So this is, as you said, at an early stage, but can you recall why you saw her point that the information sent had made for disturbing reading?
No. I'm afraid I can't.
Did you get a sense at this stage of what it was that Post Office Ltd was dealing with?
I don't think so. And I don't remember what I discussed with Angela just subsequently. So I'm afraid no, I can't answer that question.
So it is nearly 1 o'clock. I wonder if that's a convenient moment to break for lunch.
Yeah. Can you give me some idea of the timescale after lunch?
Yes, I probably have another 20 minutes at most, and then there will be some questions from call participants. I will get an indication over the lunch period as to how long they will be, sir.
Thank you very much. So 2 o'clock?
Yes, please, sir. Good afternoon, sir. Can you see and hear us?
Yes, thank you.
Good afternoon, Ms. Cortes-Martin. I'd like to continue, please, with questions relating to Second Sight. Could we have on screen, please, POL 001 01978? These are the minutes of a Project Sparrow subcommittee meeting on the 12th of January 2014. The minutes list you as having been in attendance at that meeting.
Yes, excuse me, could I
Of course.
don't think that that date is correct.
I was going to ask you about that.
Oh, okay,
Because my
sorry.
understanding was that it was April 2014 that the inaugural meeting of the subcommittee
I
happened.
don't think it's then either. Just looking at the attendee list,
Yes, I'm not suggesting that this document should be dated April. I'm asking whether it seems odd that there was already in January 2014 a formal subcommittee meeting of Project Sparrow as a subcommittee.
it is, and I wondered whether or not it was actually 2015. But I could be wrong, but it definitely wasn't January 2014.
I'm grateful. Going please to page 2 of this document, at F here, and perhaps just going back to the previous page to put this in context. There is here a section on the initial complaint review and mediation scheme, and the committee had received a paper on the current position. Just casting your eye down A to E there, does that help you at all with dating it and whether you're correct that it is in fact the 12th of January 2015?
I think so. I wasn't involved in that advice at all, but my recollection is it was either the end of 2014 or beginning of 2015 from other documents that I've been provided with.
Thank you. Going over the page, please, to F. We have here Post Office and an individual applicant, thus reducing the likelihood of a successful JR. The committee discussed Second Sight and their Part 2, due to be finalised in April. The committee agreed that the business was unlikely to be able to stop this report from being produced. Can you help with why the subcommittee reached the conclusion that the business was unlikely to be able to stop this report from being produced?
I think because it was a report that had been, I think it had been at least agreed with the working group, therefore the business would have no ability to stop it being produced.
Why was there, if we can read this in this way, a desire to stop the report from being produced?
I don't know. I can't explain that sentence in the minutes. I can't imagine that the committee would have, why the committee might have thought that it was possible.
Did this wording cause you any concern at the time?
I don't know whether or not I would have seen the minutes.
But do you recall that sentiment being expressed during discussion?
No, I don't. No, I don't.
Could we have on screen, please, POL 00116535? This is an email chain from May 2014, which you are a part of, and the subject of the emails is JA handling plan. Who is the JA being referred to here?
I would imagine that's James Arbuthnot, now Lord Arbuthnot.
Take your time if you need us to scroll down with the email. And perhaps if we can just
Could you
scroll down.
scroll down a bit?
And a bit further. And if we can keep scrolling down, please, just to give the context of the email below. See there, what we need to factor into the above is JA meeting with Paula. Does that help?
It doesn't particularly, but the only JA I can think of is James Arbuthnot, I'm afraid.
Okay. Can you help with why he would need handling?
Not a specific issue, but Lord Arbuthnot, as he is now, was considered to be a very important stakeholder, and anything that Post Office did in relation to Second Sight or the scheme was considered in the context of what and how to communicate that with James Arbuthnot. So I think it was very important, particularly to Paula and Alice, to for particularly the comms team to advise on how to keep him on side. So not, or put another way, to endeavour not to do anything which might potentially cause damage to the relationship with a key stakeholder.
Going please to one of the emails you wrote in the chain on page 2. This is the 5th of May 2014. And you're writing to David Oliver, copied to Mark Davies and Sophie Beluski. And you say, sorry for long email, but I've cut and pasted the Word doc into email as it's easier to edit on iPad. And a little further down, read JA handling plan, cut and paste from Sophie David's Word doc. I have just added a bit about positioning re-SS, so Second Sight.
Yes.
It's aimed at trying to get JA to understand that whilst they may have been the right people to do the first bit, they seem to be out of their depth on the scheme because of volume and also expectations. They are a small firm and appear to be struggling. I think overall the positioning should be that we need to keep the situation under review. With apologies for having messed up the structure below, it doesn't quite work now, but I think you will get the drift. Chris will need to agree what goes in the script, but I think Paula needs to have the plan on Tuesday and agree it so we can stop JA issuing Paula's letter, at least until she has had a chance to speak to him. So does that help with, we see reference to a script. Who was the script for?
So the script would have been for Paula to use in a conversation with James Arbuthnot, I think.
If we scroll down a little, please. Underneath your sign-off there, we have a number of headings: current situation, tactics, key messages, and then going down a little further, please. We have script there, and there are a number of bullet points there and over the page. And under script, there's quite a lot dealing with Second Sight. Can you help at all with what in this was added by you and what you'd taken from this other Word document? It may be difficult at this remove.
I'm afraid I can't. Is it any way to highlight? Is there any way to highlight it, or?
Well, how about if I take you to the section I'd like to ask you about, and you can
Yes.
see if it rings a bell with you as something that you would have input. So about halfway down this section, this page here, and if we can just skim over a little of the points under however, we now have real concerns about the pace of progress and in particular Second Sight's capacity. Pol has now received 77 detailed applications and completed investigations in a total of 22 cases, with 42 currently under investigation at various stages. Pol sent their first investigation report to Second Sight on the 29th of November. Since then, Second Sight have produced 4 reports. The first 3 were discussed by the working group on 7th of March and were sent back for restructuring and rewriting as they had not addressed key issues. They have now produced 1 report and a mediator's brief fact about Horizon, which Post Office Ltd wrote for them. On the fact brief, apart from a bit of reordering, the only bits Second Sight added were assertions and non-evidence-based opinion, which the working group agreed should be removed. Second Sight seemed to be struggling. There is only 3 of them. Expectations are high among JFSA, sub-postmasters, MPs, etc., that they will find something significant, and they haven't. But if they produce a report which is critical of Post Office Ltd without evidence, Post Office Ltd will rightly make that point. They are looking well beyond Horizon to find something wrong. Post Office Ltd cannot allow the scheme to stray into areas beyond Horizon. Their stance is they'll keep investigating until they get to the truth. That seems to be something wrong with what Post Office has done. So just looking at those points that I've been through, do you think these were your additions?
I can't recall. I think it's possibly more than likely that I would have endeavoured to change some of the wording rather than add too much of substance. But I'm afraid I can't recall.
Okay. Just focusing in on the comment, their stance is they'll keep investigating until they get to the truth. Where did that perspective or observation come from? Can you help with that, regardless of who actually wrote the words in this document?
So, I think there had been a couple of conversations with Second Sight where they talked about getting to the truth more generally, and indeed in a meeting at the beginning of sometime in the beginning of 2015, there was a discussion with Second Sight about exactly what they were looking for. So looking at Post Office's business across the piece. So what I take from this is there is the sentiments that there is a concern that Second Sight will keep on looking until they find something wrong, regardless of whether or not it's something wrong with Horizon, just something wrong in terms of the way that Post Office is managing its business more generally. That's not quite what is said here, but I think that might be the essence of it.
Just looking further down the page, please, about 2/3 of the way down. We have this: we are confident that there are no systemic issues with the Horizon system, and indeed no evidence has been found by Second Sight or any other party. Can you help with whether this was your wording?
No, but I can't recall. What I can say was that was the general view within Post Office.
What was the basis for this quite confident view that there were no systemic issues with Horizon?
Because this was the conclusion that Second Sight had reached. Not that they were confident, but Second Sight had said they had found no systemic, I think these were their words, or they'd found no system-wide or systemic issues with the Horizon system. And as far as the Post Office was concerned, that was the case in 2013 and continued to be the case at this stage in the process.
So that is your understanding of the systemic issues reference, that it is used in the same way that Second Sight had in their interim report, notwithstanding them having found bugs and defects.
I think so, yes.
Could we have on screen, please, SSL 40120? This is a transcript of an audio recording of a conversation that you had with Mr. Henderson and Mr. Warmington on the 11th of August 2014. I understand you've been provided with this document, but relatively recently, is that right?
That's correct, yes.
There's only one section I want to take you to. Just going to page 24, please. And scrolling down the page, please. The last entry here, Ron Warmington, who says, "Okay, Belinda, I tell you what, how we can characterise this discussion. It is the antithesis of what I was assured by the Chief Exec and Chairman, which is our work we pledged to you, because I said I wouldn't take on the job unless they agreed to this, is to seek the truth as to what has happened, all right? The characteristics of the conversation we are having are one of litigants, one against the other, trying to defend their case. It's perfectly acceptable and perfectly normal, but a search for the truth would have been far less an effort to protect the organisation from an attack, but more a sort of volunteering of what the entire background was." Do you recognise any truth in this? That the Post Office's stance in this stage of the mediation was that of a litigant trying to defend its case?
I think that as the focus of the scheme in the view of the Post Office was around particular cases as opposed to Horizon across the piece, or indeed the business of the Post Office as a whole, I think that could perhaps characterise in some part the position of Post Office. If I make it clear at the beginning of this conversation that I'm only having the conversation with Second Sight because this all arose in August and pretty much everybody was on holiday. So I think I make I say at the outset, I'm speaking on behalf of Post Office, and I think I was having the conversation in the absence of Chris, who was away. Therefore, I was that doesn't mean to say that I'm not owning the statements I made, but I was putting Post Office's view across, and I would say that to some extent, Ron is correct.
Whose view were you putting across? I understand it's the Post Office position, but who had made you understand that to be the way Post Office was approaching this? So
I can't say that it was, as with many of these things, I can't say necessarily that it was anybody's particular view. I can't name somebody who said this is the way that we're going to approach it. What I would say is that this is the way that the approach was developing. Not as, I don't think quite as noticeably as Ron was saying, but that was certainly how they felt about it. So, and I think, looking at the documents and what happened subsequently, I think probably in part this was informed by the Linklaters' advice.
Turning please to the disclosure of material to Second Sight, and that document can come down now, thank you. At paragraphs 49 and 50 of your statement, and I don't think we need to go to them unless you wish me to, but you refer there to believing Chris Ojard and later Jane MacLeod as General Counsel were responsible for deciding the documents or information to be provided to Second Sight. Is that right?
Yes.
But you do say you would offer assistance and opinion on such matters if you felt it was necessary?
Yes.
Could we have on screen, please, POL 002-10527? This is an email from Mr. Ojard to Mr. Warmington dated the 10th of October 2014, but I think we need to just scroll down a little, please. Yes, it's sent on his behalf from a different email account. And you were copied into this email where Mr. Ojard explained why the Post Office would not grant Second Sight access to prosecution files.
Yes.
Have you had a chance to read this email when it was provided to you? He notes in the last paragraph of his email, scrolling down a little please, in any event, with our investigation reports, we have already provided you with any relevant source material found in any Post Office prosecution files, i.e. transcripts of interviews, witness statements, etc. The material is, of course, used by Post Office's security and prosecution teams to consider and, if appropriate, conduct prosecutions. However, the resulting internal documents are legally privileged. It is outside your scope of work to review Post Office's prosecution practices and decisions, and so I see no need to disclose this documentation, which, just to be clear, has also not been released to Tony. Nevertheless, the underlying source material provides you with the factual information arising from any previous Post Office investigation, and so you should have what you need to undertake your review. Did Mr. Ojard discuss the reasons behind withholding these documents from Second Sight for privilege reasons with you at all?
No, I knew this was his view, but he didn't seek my opinion or advice on it, particularly because these were legal documents and matters of legal privilege were broader than I think my knowledge or understanding.
Could we have on screen, please, POL 002-14354? This is an email chain from December 2014. And on the 10th of December 2014, you emailed Mr. Ojard, forwarding an email from Mr. Parsons regarding Second Sight's questions for Post Office to inform the Part 2 report. And just scrolling down so you've got the context for that. We see in that bottom email, Mr. Parsons refers to some sensible questions. There is also a massive fishing expedition for information that does not address issues raised by the applicants. And scrolling back up, please, to your email. And you say, Chris, you need to have a look at this. It's Second Sight's list of questions to inform Part 2. You will see that this is a pretty considerable fishing expedition, which includes a lot of general requests. We will need to do a formal response setting out where we are not providing information, for example, the contracts, investigation procedures, but grateful for your view on approach before I start this. Can you recall now why you considered the requests to be a fishing expedition? I appreciate we're not looking to the detail of those, but does this ring a bell with you at all as an issue?
It does, insofar as there had already been I think a number of exchanges and conversations within Post Office about the extent to which Second Sight might ask for either raw or base data, or a lot of general information that didn't relate specifically to an application. And so it was already, I think, the view that had been set out to Second Sight, I think probably in relation to the 2008 emails. And so that was the context in which I sent this email.
Could we have on screen, please, the last document I want to go to on disclosure? It's POL 001 02245. This is an email from Mr. Ojard to you dated the 27th of February 2015 regarding the request made by Second Sight for further access to files. Mr. Ojard says this in his second paragraph. Access to files was originally granted before my time in relation to an entirely different assignment, the broad terms of which were agreed with Second Sight in June 2012. From what I can see, the background to that review was that we wanted to conduct an independent review of a number of closed and possibly some open fraud and theft cases. That review, or a variation on it, was undertaken before the working group was formally established, and although it is hard to pinpoint the precise end date, it would seem to me that it did not survive beyond the publication of the so-called spot reviews. It also seems to me that it was conducted for our benefit, although it was expressed to be an independent review. For this reason, more liberal access was granted to our internal records, etc., than is fitting in current circumstance. Rod is doing a more detailed technical note explaining the reasons why. What was your understanding of, or do you recognise at all this reference to Second Sight's initial involvement being conducted for Post Office's benefit?
No.
Was this something that you noted with any surprise at the time on reading this email?
No. No. Could you show me the date of it again?
Of course, scrolling up, please. It's the 27th of February 2015, and it's in the context of a request from Second Sight for further access to files, so it's on the question of disclosure.
Right.
And what this second paragraph does is to refer back to disclosure that was previously given for, on the basis of the author's view, a different purpose, and that purpose being, although it was expressed to be an independent review, it seems to me it was conducted for our benefit. And the suggestion here is that because it was for Post Office's benefit, more liberal access was granted to internal records than in the circumstances of the scheme and this date and time.
So I don't recall this. The reason I'm hesitating slightly is until I watched an evidence session last week, I don't think I'd have had any idea what this was referring to, but I think I do now. I think it was a report Second Sight did for Susan Crichton, just simply because that's how it reads to me now, but I wasn't aware of it at the time. This was primarily an email from Chris to assist Jane MacLeod as the incoming General Counsel. And looking at the timing of it, this was about 4 weeks before I was due to leave. And I have to say, by this time, I was starting to, I was tidying up things so that I could leave and things would have been handed over. So I probably wouldn't have paid too much close attention to this because this was no longer an issue that I would have been involved in going forward. So I don't remember seeing it. I don't remember seizing on it or questioning it at the time, but I do now think I understand what it relates to.
Okay. Just one more point on this document before we move on, please. It's the bottom of page 2. And so this is your email. And if we, to give context, if we can just scroll up to show the top of the email. With a subject catch-up call with Second Sight.
Yes.
And towards the bottom, please, the penultimate paragraph gives a note, and you refer to colleagues who are due to meet with them may also wish to note a marked change in tone and behaviour in recent weeks, notably from Ian. Is that Ian Henderson? He is much more aggressive, accusatory, defensive in tone than our previous experience. I would speculate that this frustration because they are still struggling to find a smoking gun and feel the weight of expectations from others to do so, especially after the Select Committee. The change is marked, and it is worth keeping in mind ahead of next week's meetings. What was the reason that you came to this view on the cause of Mr. Henderson's frustration, that they couldn't find a smoking gun?
It was speculation, nothing more than that. So I had felt on numerous occasions that the expectations on Second Sight were great. I do realise, in view of what's subsequently come out and what's subsequently known, that this, what I'm saying now may sound rather odd, but at the time in Post Office, I still detected a level of confidence in the Horizon system, and but Second Sight were under pressure to find something that hadn't previously been found, and that was the reason for my speculation.
Turning briefly to the closure of the mediation scheme, you deal with this at paragraph 96 of your statement. That's page 47. If we could have that on screen, please. And you say here, I was clearly involved in some but not all discussions on amending, closing the scheme. Ultimately, it was the subcommittee, presumably endorsed by the board, that decided. As far as I recall, my view was that it was a matter for Post Office Ltd to decide what it wanted to do. I think that I felt that if the original idea of some of the scheme was aimed at hearing sub-postmaster complaints, with a view to resolving complaints and drawing a line under the matter, then it had not worked. If anything, some sub-postmasters and JFSA seemed less happy than when the scheme started. Second Sight was publicly critical of Post Office Ltd, and there was, as far as I recall, a notification of legal action by a group of sub-postmasters in the future. As such, I agreed that there was little point in carrying on with the scheme in the same format, as long as those applicants remaining in the scheme were able to have their complaints investigated and mediated, as they had been expecting. I was also leaving shortly, so whatever decision was made, I was unlikely to be involved in next steps. And at 97, you add, in terms of what Post Office Ltd wanted out of the scheme and the working group, from the documents provided to me, I cannot see that the outcomes Post Office Ltd desired were achieved. This may be the reason why a decision was taken to close down the working group and scheme. I think and hope that at least a small number of applicants in the scheme who submitted a complaint which was resolved were satisfied. Picking up on the question of what the Post Office wanted out of the scheme, could we have on screen, please, POL 30-27506? This is the Executive Committee agenda for its meeting on the 19th of November 2013. You do not appear to have been present at this meeting, but I'd like to ask you about one part of a paper which appears to have been presented by Chris Ojard. We can see the first item on the agenda is the update on Horizon, and especially the draft settlement policy for the mediation scheme. The paper starts on page 2 And we can see there the title. And going please to page 3 to paragraph 4. The title is Ensuring the Success of the Scheme. And at 4.1 it says this: Post Office has invested time and money in creating the scheme and positioned it with the media, MPs and JFSA as the response to the second site report. It is therefore important that the scheme achieves its objectives and is generally acknowledged as being successful in answering the concerns of sub-postmasters. From the Post Office's perspective, the scheme will have been a success if, when it has completed, first, the media, MPs and JFSA consider the scheme fairly investigated and, where appropriate, addressed the sub-postmaster concerns identified in the second site report, even if there is disagreement over the outcome of individual cases. And then this at the second bullet point: Post Office can more robustly defend its use of the Horizon system against criticism by a minority of sub-postmasters who, despite best efforts, remain entrenched in their dissatisfaction with Post Office. Were you aware that one of the Post Office's desired outcomes for the scheme was to robustly defend its use of the Horizon system against criticism?
No, not as such, but I was aware that Post Office hoped that at the conclusion of the scheme, there would be a higher level of understanding and satisfaction with, no, maybe that's, so definitely I did not know that this was to allow Post Office to more robustly defend the Horizon system in those terms, but I did think that Post Office would feel that they had undertaken a thorough investigation of the complaints that had been raised, and if nothing had come out in relation to Horizon, then there would be less dissatisfaction with Horizon. I'm really sorry, I haven't answered that very well, but that is a stark outcome is not my understanding, but probably something more nuanced was my understanding.
Was the Post Office's stance to defend Horizon throughout the mediation scheme?
No. Not at the expense of anything else. That was not my understanding. But I think the Post Office's stance was definitely to defend Horizon in the absence of finding anything that suggested to Post Office that it was not working as it should.
Looking at it in these stark terms, do you think that this objective or this desired outcome hindered the mediation scheme from having a positive outcome?
I'm not sure that I can answer that question. I certainly felt that during my time in the scheme, and as I think I say in my statement, I didn't often have cause, by virtue of my role, to look at the investigations, but my understanding was that Post Office had an answer for everything. And so whether or not having that answer actually stopped a more open-minded approach to Horizon and its faults, I don't know. Like I said, I struggle to answer that. What I did feel from my position inside the scheme, and that's the processing of the scheme, was that a huge amount of effort went into making the scheme as good as it could be, but that might be more a process point than anything else.
That can come down now, thank you. Just one final matter from me. In answer to one of my questions this morning, you said that it was a matter of regret that you didn't challenge Andrew Parsons' suggestion that the importance of the Rose advice be downplayed. You suggested, and I hope that I'm right in characterising it as such, that this was among many regrets. What are the other regrets you were referring to?
So I suppose sitting here now, I regret not digging down deeper into some of the issues that clearly passed my desk, because had I done so, I might have asked more questions. I can't guarantee, because this whole issue continued well after I left, that it would have made any difference. But it's quite, looking at the documents this far after the event, I've looked at a few and thought, I could have done something differently with that, and maybe that would have made a difference. What the perspective I don't get on this is looking at what my inbox would have looked like and other things that I would have been doing, particularly preparation for a working group at any given time. Like many people, I'm just selective about the issues that I pursue with any depth. But so I don't know that I could be specific. I could probably come up with a list if you needed it, and I would say regretting being involved in it any way at all is my biggest regret, if I'm honest.
So those are all the questions that I have. Do you have any questions before I turn to call participants?
No, thank you, no.
We have some questions from Mr. Jacobs first, and then from Ms. Page, and I think that is it.
Right, thank you.
Good afternoon, Mrs. Cortes-Martin. Ms. Cortes-Martin, I hope you can hear me well enough. I represent a large number of sub-postmasters who are call participants in this inquiry. I want to ask you about Project Sparrow and the disbanding of the working group. Could we go to a document, please, POL 000-21908. While we're waiting for that to come up, I'll tell you that this is an email that Andrew Parsons of Bond Dickinson wrote to you, copying in Mr. Williams and Mr. Matthews on the 9th of February 2015. And we'll see it starts, Belinda, a few thoughts below on the Sparrow paper. Now, we know, of course, that you were the programme director of Sparrow, and we also understand that around about the February 15 time, there was a Sparrow meeting, and there were suggested amendments to the mediation scheme raised at that meeting. Is that?
Yes.
That's right. What Mr. Parsons says in the first paragraph is, in general, I agree with the idea of disbanding the working group, as one, it offers no real value, and two, it is the source of much criticism of Poll. And then he says he can see some challenges with other suggestions. So just looking at that, Sparrow had proposed that the working group be disbanded. Is that right?
I don't know that Sparrow had proposed. I think that the proposal came from a meeting of the executive committee,
right,
for ExCo. I don't know that Sparrow, by that stage, insofar as it existed other than a name, actually proposed anything.
But quite clearly you knew about the any particular conflict between your role as programme director of Project Sparrow,
yes,
and the secretariat function that you've had with the working group.
Yes.
There was, we understand, a meeting of the working group on the 13th of February 2015, so shortly after this, and the agenda, which I think you prepared, shows that this issue didn't come up. Did you feel at this point, here you are, you're assisting Sir Anthony Hooper, assisting the work of the working group, You are involved in discussions that are surrounding the disbanding of that group. Why didn't you think you should say anything at that time? Or perhaps I'll rephrase that. Did you think you should have said anything at that time?
So, again, from the outside, a long time afterwards looking in,
Of course.
I see things differently. So, the discussions within Post Office, both at executive level and board level, about altering the scheme or closing the scheme had been continuing by this time, probably for about a year. I think there was a Post Office board meeting in February 2014. And although the matter of the working group and the scheme was under review, and my team were asked to offer a number of proposals for altering it, nothing ever happened. So I think that it was too difficult to make those decisions. And so because I saw my role as largely just running the scheme, I just continued to do that to the best of my ability. And I don't think I ever really thought that there was any real prospect of the scheme closing. Okay. Was one point. The other point is I didn't see my responsibilities in relation to the working group going so far as to say to the working group what was being discussed in Post Office.
Well, I'll move on.
Hang on, that's the point, really, isn't it? That you were learning things by virtue of your role as director of Project Sparrow,
yeah.
i.e. an internal Post Office group of people, which on occasions might have put you in conflict with your role as secretary to the working group and Sir Anthony. I'm not saying they did in your case, but I'm talking about what might have happened.
And I see that, which is why I think I say, looking now and looking in, I can see where that might have been the case. But it didn't feel like that at the time. The point at which it felt like it was the point at which actually the subcommittee made a positive decision to close the working group, or to disband the working group and alter the scheme. And I think that was the point that, although I wasn't going to be at the subsequent working group meeting, I raised the question with Jane McLeod, who was the new Post Office General Counsel, to say, I think the programme team need guidance on how to manage the next working group meeting in light of the decision that has now been made. Because prior to that, I don't think any decision had been made.
Okay. Thank you. So what you're talking about is round about the time of this email, isn't it? When they decided to close.
Yes. I think it was subsequent to that.
Right. If we can go to the next paragraph then, so where Mr. Parsons talks about Second Sight's role, he says, if Second Sight are independently contracted by the applicants, that was one of the suggestions that was floating around. He goes on to say, I cannot see how Poll can dictate Second Sight's scope of work. In what way did Post Office seek or want to dictate the work of Second Sight? Dictate is a very strong word to use, isn't it?
It is. I'm afraid I can't answer that question. I wasn't aware that... So Post Office wanted to set the scope of Second Sight's work insofar as, and I think previous documents will show that, insofar as Post Office felt that Second Sight should not be looking at prosecutions and should not be looking at matters of contract. So I think that's the point in relation to dictating the scope. I think dictating is a strong word.
Well, Mr. Bates gave evidence on the 9th of April, and he said that at all stages until the group litigation, Post Office were very, very anxious to control the narrative, to control the process. And that's what Post Office were doing here, isn't it?
In terms of
dictating what Second Sight were doing, controlling them.
I can't speak for Andrew, but I wouldn't have put it in those. I wouldn't have put it in those terms. So I'm afraid, sorry, I can't help you more on that particular point.
We'll move on to the next paragraph, where Mr. Parsons says, similarly, without direct control over Second Sight's scope of work, it will be very difficult for POL to stop applicants aggregating their funding to pay Second Sight to produce a Part 2 report. So what Mr. Parsons is telling you here is that the Post Office need to control the process, control Second Sight, because we don't want Second Sight to produce their final report, because Post Office will not like what Second Sight are going to say. That's the point, isn't it?
I think so, yes.
So this is an attempt to control the process, isn't it?
Well, I think it's Andrew's view of what Post Office might do to control the Post Office, if that's to control Second Sight. I don't know that can be said to be Post Office's view, because I'm not aware of that, and I'm also not entirely sure why Andrew felt the need to send it to me rather than to send it to the authors of the report, and I would imagine I would have sent it to the authors of the report.
Well, moving on, yes, moving on to the bottom of page 1, the paragraph that begins, I wonder, it's just before the section mediating all non-criminal cases. So Mr. Parson also then says to you, I wonder whether POL would be better keeping Second Sight under direct contract, and then without the working group, POL could more easily dictate Second Sight's work, i.e. stopping Part 2 and focus on cases. This has the advantage of narrowing Second Sight's role whilst maintaining more direct control. Now, my question to you is, Mr. Parsons isn't an outlier here. These aren't sort of wild suggestions. This is part of the discussion that's going on, and you were part of it. Can you comment on that and what Mr. Parsons says, please?
So, I'm not sure. As Mr. Parsons has only sent it to me, it seems to me as though he's hazarding a view, but he's not entirely sure whether or not how that will sit within the Post Office. Therefore, he's only sending it to me. Andrew was involved in anything to do with the scheme and other issues throughout the whole of my time on the scheme, so he was very much involved. I don't know that his views always prevailed or always represented the views of Post Office. I read this as him saying this is what Post Office could do. I didn't feel that this seems to me to be quite extreme in terms of what Post Office might have wanted to do.
Let's move on then to the last part, mediating all non-criminal cases. So Mr. Parsons goes on to say, mediating all non-criminal cases, of course, means mediating lots of hopeless cases. Mediating unmeritorious cases raises applicants' expectations unfairly and may, in fact, create greater animosity and complaints. Certainly that was my experience from, and he names one of the cases. My recommendation would be for POL to take a tougher line and only mediate meritorious cases, even if the bar for this is set low. Now, that's what he suggests, but the real reason is the next paragraph. This would also be consistent with the principle of not mediating criminal cases. Now, you know that the Post Office didn't want to mediate criminal cases. That's right, isn't it?
Yes, they were taking it on a case-by-case basis.
And he goes on to say what the primary reason for that is. And this is what he's saying to you. Although the primary reason for not mediating the criminal cases is the criminal risk Another way of seeing them is simply as cases that lack any merit because the applicants have committed criminal offences. The criminal risk, of course, is that if those that have been convicted get more information from the mediation scheme, then they could go to the Court of Appeal and seek to have their convictions overturned.
I can't account for Andrew's views, and I don't really want to try. I think, but in terms of your last point, the cases that had been subject to a criminal prosecution were entered into the scheme, those that applied, and they were investigated and they were provided with information. I'm not sure that the mediation as such would have made any difference to the information that was given.
Very well. Well, finally then, last 2 points on this letter. Mr. Parsons says, taking a stance that POL will not mediate unmeritorious cases has the advantage of carving out more cases as well as avoiding the criminal cases without having to base this on unattractive legal risk argument. So Post Office didn't want to have to say we don't want to mediate criminal cases because it might transpire that there were miscarriages of justice. They wanted to be able to say, well, because they're not meritorious.
So I think I have to refer to my previous answer, and that is I can't speak for Andrew, but also I think he's making it clear that this is his view or a recommendation, and particularly on matters of criminal prosecutions and what could and couldn't be achieved, that is an area that I would try to avoid in any event because I'm not a criminal lawyer and I don't understand enough to be able to speak with any sort of competence on it.
Well, Mr. Parsons ends his message with happy to discuss. Mm-hmm. Now, presumably, what he said was you might have been surprised, might have been shocked, or you might have expected it. But did you discuss this with him, as he seemed to be suggesting?
I think it's highly unlikely.
And why is that?
Because this particular discussion about the scheme came out of a conversation at EXCO, I think, and it was based on the drafting of a paper for the board, the subcommittee, and the paper was drafted by Jane MacLeod and Mark Davis. So if anybody wanted to discuss this with Andrew, it would have been for them. I would imagine if I did anything with it, I would have sent it to them.
This was the 9th of February 2015. Now, I know that you left and you retired on the 31st of March 2015, so this would have been right at the end of your career with the Post Office. Do you remember this? It was at the end. It was, quite a significant letter to you?
I don't. So there have been one or two emails that I've seen in the bundle that Andrew has sent to me, and I've not been entirely sure why he sent them to me or just sent them to me. This is in that category. But definitely by this stage, these were issues for EXCO and the subcommittee, and I wouldn't have engaged with Andrew over I mean, I can't guarantee, but I can't imagine picking up the phone and discussing this with him. Insofar as I might have had a conversation with him, I might have said, do you want me to just send this to Jane and Mark?
So I have some more questions on the question of suspense accounts where Miss Cortes-Martin was involved. I know at the time, I don't know if you would wish to take a break now or continue.
Oh, let's hear you out, Mr. Jacobs. I'm sure we can do it reasonably swiftly, and then we may take a break.
Indeed. Could we go to POL 000400805? And could we go, please, to page 3 of 4 in this document? It is an email that you sent to Ruth Phillips, dated the 15th of January 2015 at 16:59. So scrolling down, please. And you send it to Tracy and you ask for this to be passed on to Alistair. Is that Alistair Cameron?
Yes.
Yes. And you say, Dear Alistair, I understand that Chris Ojard has spoken to you about the discussion at yesterday's working group meeting of the complaint and mediation scheme. For some months, Second Sight and the independent chair of the working group, Sir Anthony Hooper, have been asking for information on the operation of Post Office's suspense account. Put simply, this amounts to, and then how much of is absorbed into the Post Office P&L, that's profit and loss, from the suspense account each year, and how much of that is connected to money which is or may be properly due to sub-postmasters. And you go on to say the nub of the issue is whether it is possible for a sub-postmaster or sub-postmasters to have made good a loss in branch or held accountable for a loss where it later transpires that the money was not owed and therefore Post Office gains. So the point that Sir Anthony was raising is that sub-postmasters may have paid money into the Post Office on account of horizon shortfalls that may or may not have been real, and the suspense accounts would assist on showing whether the shortfalls were real or not. Mm-hmm. If we could go to, and is that your understanding of what Sir Anthony was asking?
Yes, I think it is.
And he'd asked it on many occasions, hadn't he?
In various forms. Yes.
Sir Anthony gave evidence on the 10th of April, and he said he asked quite a few times, repeatedly, and he said, I got absolutely nowhere, and nor did Second Sight. Never got the answer. If we could go scrolling down to Chris Ojard, page 3 of 4. He writes an email, and here we go. 16th of January 2015, 8:08. So on the same issue, he's saying, as you will see, I really need someone from your team who is technically switched on raise suspense accounts and can handle themselves in front of an adversarial audience. As you can imagine, I'm concerned that we give Second Sight no more information than is necessary to address the narrow proposition that money that is missing from an SPMR account is somehow taken into our suspense account and then appropriated to our P&L, profit and loss. So Mr. Ojard was very resistant to giving information to Sir Anthony and to Second Sight. Is that right?
That's not my understanding or the way that I read this.
Okay.
I think if I understood the situation correctly, he's saying he doesn't want to give Second Sight any more information than necessary to address that narrow proposition, which I think was Sir Anthony Hooper's proposition.
Okay. If we then go to page 2 of 4, we'll see that there was a suggestion that Rod Ismay addresses this point. Do you see, you wrote an email on the 16th of January 2015, and you said, I understand you're both speaking with Rod today about suspense accounts. So the proposal was that Rod Ismay would discuss this with the working group?
I'm not sure if discuss it with the working group or Second Sight.
Right.
Can I say something about the suspense
Yes,
account issue? So the suspense account issue, and as with some other issues, were issues that I was involved in coordinating. So there were conversations, some of which I wouldn't have been involved in terms of how to get the information required. So my interest in this was that this information needed to be provided. It was a matter for Post Office to determine what information it provided. If Post Office didn't provide all the information that second site needed or Sir Anthony Hooper wanted, then that needed to be a matter of record and Post Office would have to deal with that. But my involvement in this was trying to coordinate activity so that by the time of the working group, if that was the deadline, this information had been provided.
Well, one last document to show you is POL 000211762. And while we're waiting for it to come up on the screen, I can say that this issue, you were involved in this issue prior to this, back in July or August 2014, weren't you?
From the very first
account.
instance,
Yeah.
it arose, yes.
So if we go to page 3 of 5, we have an email from Andrew Parsons to you and Angela Vanden Bogard, and he says, and this is after Ian Henderson had asked for all the suspense accounts, and Mr. Parsons says, Belinda, Angela, as discussed briefly yesterday, I suspect that the information requested by Ian is highly commercially presumably sensitive. It may also be that the figures in question are quite high, and this may then be portrayed as if there are significant sums each month that can't be reconciled with Pol's accounts. The inference from this is that Pol's processes accounting systems are flawed given the volume of discrepancies. Whether or not this is correct, it is an easy leap to make. Assuming that Pol Finance say that this cannot be disclosed, I've penned a short response to Ian below, and then he just says it's commercially sensitive. So again, we've got Andrew Parsons also saying to you, Post Office doesn't want to give this information to Second Sight, let alone Sir Anthony Hooper. Would you agree?
Yes.
And then if we have Chris Ojard making the same point at page 1 of 5, the 1st of August 2014, 7:38 p.m. He's writing to you as well. He says, Belinda, I agree with Andy. I'd like to avoid giving anything, if at all possible. Less is more. But if we do, I'd rather give them the data, rather than give them the data they've asked for, we should provide, I think, MI's management information, which gives context. And then he says something along these lines. The amount held in the suspense accounts across the Post Office network averages XX per trading period, or approximately Y of the total value of the transactions processed each trading period. Of the sums held in suspense accounts, approximately Z% is cleared within 13 days, but 30 days, and all but F% is cleared within 90 days. So really, my question for you is, this was a recurring theme from Second Sight and from Sir Anthony. You were directly involved in this, and you knew, because so many people were telling you, that Post Office were absolutely determined never to give this information out. That's right, isn't it?
Again, I don't necessarily read it that way.
How do you read it?
Well, it's not give anything out, but clearly what Post Office was inclined to do was to only give out whatever information it felt was appropriate. I think it was ultimately a matter for Alistair Cameron and Chris to decide what information went out. So as far as I'm concerned, Andrew and Rod were telling the wrong people, and I would just have passed their advice on to the people that were making the decision.
Well, I can see that you're saying that you were effectively the messenger, the conduit.
Yeah.
But I do have to ask you this question, because it seems that you did have significant input in this matter. Do you accept that these accounts, if Post Office had disclosed them, could have demonstrated that the shortfalls were not real, and that this could lead to a presumption that the Horizon system that was generating these figures was actually to blame and not the sub-postmaster? That's why Post Office didn't want that material to come out, isn't it?
So I see exactly what you're saying. It is not something that I concerned myself with.
No.
I understand that it's one of those what Ms. Price was saying, do I have any regrets? But this is an issue that I did not get into the detail of. I didn't understand it. in terms of the detail of the suspense account, and as far as I was concerned, it was a matter for Post Office to determine what information it gave and to who, and Post Office would stand or fall by its decisions, but they weren't my decisions. So I understand what you're saying, and I realise it sounds as though I'm saying nothing to do with me, but in reality, I wasn't in a position to make those decisions, I wasn't in a position to influence them, and I did not attempt to do so.
Well, my final question for you is in relation to what you told Ms. Price. You said you regretted not digging down deeper. You were in a position to have dug down deeper on this issue. Do you regret not doing so?
This and many others. What I don't understand, so subsequently many things have come to light, some of which clearly crossed my desk, many of which I think did not. It would be difficult for me to single out one particular thing, but what I don't want to do is to give the impression that it was my role to do this and therefore I was not doing it, simply because that's not the case. But what I regret is that there were things that crossed my desk, and had I drilled down into them, I might have been able to highlight more. There are many things that I could have done differently, but I didn't. This isn't a standout issue.
I just want to ask if I have any more questions for you. Thank you. I don't have any more questions. Thank you.
Right. Ms. Page, how long do you expect to be?
15 to 20 minutes, sir.
Right, we better take a break then, 10 minutes.
Thank you,
So
sir.
what time should we start?
20 past, sir.
20 past, right, fine.
Thank you. Hello, sir. It's over to Ms. Page.
Yeah, fine.
Where did your loyalties lie during your period working for the Post Office?
I'm not sure that... when I was doing work for the working group and the chair, then my loyalties lay there. And when I was doing work for Post Office, my loyalties lay there.
Once you were working for the Secretariat, as you've described it, did you feel that you owed any obligations to Second Sight?
No.
Can we look, please, at poll 0030 0442? And if we look, please, at the bottom half of the page when it comes up. Bottom half of the first page. So on the 22nd of October of 2013, that's not long after you began.
That's correct.
You say to Angela Vanden Bogaard, Angela, I said I would do a note about how to move to a place where Second Sight are able to leave the working group and allow Post Office take over sole responsibility for the investigations. That's pretty clear, isn't it?
In terms of the note that I was going to do, yes.
So you were asked to look into moving Second Sight out of the working group altogether and allowing Post Office to take over sole responsibility, yes?
I think so. There was an email that we referred to earlier, I think, which was an email from Andy Parsons, which had said, had suggested that a decision or plans were already in place to move Second Sight out. I assume that this followed on from that, so I assume that those were plans that were already considered by Post Office, and I was asked to do a note.
Exactly. So you were well aware of the Post Office's plans at this point in time. If we could have a look at your witness statement, please, where you deal with the Parsons email. And it's at page 28, paragraph 59.
Yes.
We'll just wait for it to come up on the screen. Now, you say there, I'm unable to explain the background to Andrew Parsons' suggestion within the email that you were just referring to, and then quoting from it, work is continuing on managing SS out of the scheme. In general, SS role is gradually being reduced until they can be removed entirely. This work has already begun. So there you say you're unable to explain the background. Now that's fair enough, but the fact is you were then commissioned to do a note on the subject, and you don't mention that in your statement. Did you forget about it?
I don't remember being asked to do it, but I had seen it, the email that you referred to earlier was in my document, in my document pack.
Well, the email I took you to was in fact in the second document pack, so you didn't have it when you made your statement. Had you forgotten about it when you made your statement?
Well, I definitely didn't recall it.
Well, in any event, the combination of these emails, thank you, the statement can come down, makes it plain that you knew from the outset that Post Office wanted to get rid of Second Sight, didn't you?
I knew that Post Office wanted to reduce the involvement of Second Sight. So
well, that's not what they say, is it, these emails? They say that they are to be removed completely from the scheme and Post Office is to take over the role completely, exclusively. They didn't want to reduce it, did they? And they made it perfectly plain to you because you wrote a note about it. They wanted to get rid of them, didn't they?
So I haven't seen the note that I wrote, or indeed whether I did, but certainly the plan was to remove second sight. What I'm not clear on, because I can't tell from the documentation, and I don't believe I ever got to the bottom of it, because I think, as I said previously, I don't know that I ever managed to speak to Susan Crichton about it, is exactly whether that related to immediately, or when the work of that, when the mediation scheme as set up, which was clearly envisaged to last for a very short period of time, whether or not the plan was for second sight to disappear after that.
Ms Cortes-Martin, this set the tone, didn't it? This was the first thing that you were asked to do, more or less, and it made it plain that your loyalties were with Post Office, and that if there was a disagreement between Post Office and second sight, your loyalties would be with Post Office, wouldn't they? Because you were asked to find a way to get rid of second sight.
So I don't know that I had loyalties to anybody, but but Post Office were responsible for the scheme, and if Post Office wanted to run the scheme in a particular way, as far as I was concerned, that was a matter for Post Office. I didn't have any particular loyalties to Post Office or second sight. I mean, in relation to loyalties to Post Office, I had not had a career with Post Office, and I was leaving Post Office. I didn't feel that I had a particular obligation to do anything in defence of Post Office, but if Post Office asked me to explore options for second sight leaving the scheme, then that's what I would do.
Well, let's have a look at what else you were asked to do. If we could bring up poll 0016 4253, please. This email chain is from December of 2013. And if we scroll all the way down to page 5 when it comes up, please. So if we just scoot down a little bit further. It begins with Roger Williams to Jarnail Singh copying you in 3rd of December 2013. Jarnail, senior management has asked for the current position on prosecutions. When paused, / what do we have in train? So these two lawyers had both received the clerk advice, and indeed both of them were instrumental in managing the aftermath of the clerk advice. And I'm talking about the July clerk advice that Miss Price took you to earlier on. Here they're discussing current prosecutions, and the question is, when were they paused? Now, the fact is that the clerk advice required a pause because it discredited the expert witness that was in use, and there was no one to testify to the integrity of Horizon records. So this looks like an email chain dealing with the response to the clerk advice. Does that make sense?
If it was, I wasn't aware of it. I think it was an email chain to get information to inform a board paper.
Indeed, we'll come to that. If we go up first, please, to page 3. And I think we just go, a little further down. Yes, it changes slightly. Mr. Williams says, thanks, I have another question. Do you know who was responsible for prosecuting cases before separation? In whose name were the prosecutions brought? Who was the prosecuting authority? And who would ultimately be responsible if a prosecution was found to have been improperly conducted? And again, you're copied in. Yes?
Yes.
So we're now moving to past prosecutions. Having talked about current prosecutions and when they were paused, it's now looking at past prosecutions. And as you say, if we then go up to the top of this chain, we can see that on the same day you take over this line of query. And you do so, as you said, because you've been asked to deal with an action. And you tell them, I now have the actual action from the board. And you give a deadline. And then you say the action is, the board asked for a note from the General Counsel explaining who was named in past prosecutions and the liability for the business and individual board members. The note should also include information on both PI and D&O insurance cover. D&O was Directors and Officers insurance cover, wasn't it?
I think so, yes.
And so the board were concerned about their personal liability for past prosecutions, yes?
So I was asked to address this in my statement. The board asked for advice from General Counsel on it. I probably take the question quite literally, but I don't know whether or not they were concerned or they just wanted advice on it.
Is that really your answer? Are you suggesting that the directors wouldn't be concerned if they were seeking advice on their personal liability for wrongful past prosecutions?
No, I'm not saying. As I said, I think I'm taking the question quite literally. I'm not aware of any particular that they were worried about it, but that they were asking advice on it. Now, that could be driven by concern, but what I don't know is what caused the request for the information.
Well, surely you would have found this out from Mr. Singh or Mr. Williams, the two lawyers who had begun this email chain and who could have given you the answer.
I don't know.
You weren't curious, I see. You've then gone on to deal with the personal liabilities, but before you do that, you say, under the heading, just a little further down, prosecution's already in process before we paused. I will insert the information provided by John L. earlier today. So no curiosity at all there about why they'd been paused, no?
So my understanding was that prosecutions had been paused because of the scheme.
Sorry, explain that.
My understanding was that Post Office had decided to not to continue with prosecutions while the scheme was in process.
I see. You then go on to deal with the liability for individual board members in a little detail. I won't take you through that. But what happens next is on the 6th of December, there's a further email chain, and it's Pol 0019 8765. And if we go down to the crossover between page 2 and page 3, please. Yes, thanks. Sorry, just a little further up again. So it begins with David Oliver sending to you Chris Ojar, Roderick Williams, Jarnell Singh, under the heading board paper, no doubt the board paper that you were putting together. It just has an attachment, civil claims risk response.pdf. And then if we go up, we can make a bit of sense of that because Mr. Singh, if we pause there, there's a line starting on the 13th of December 2013, Jarnell Singh wrote. We can then see what he writes. He says, having read the Bond Dickinson note, and that's evidently the one which was attached to the below email, I was concerned that the likelihood of action being brought had not been assessed. Accordingly, I asked Cartwright King to review Bond Dickinson note. I attached Senior Counsel Simon Clark's response, which clarifies the issues. And so evidently he has attached a further advice. Now, first of all, that tells us that the Bond Dickinson note was one which, as far as Mr. Singh was concerned, didn't cover the likelihood of action having been brought against board members, yes? So this is dealing with, both of these advices are dealing with actions potentially being brought against board members, yes?
I'm not entirely sure. I'm sorry, but at an early stage in the process, I was asked to pull together a board paper, the outline of which, or the action I was given, and the outline of which I would have discussed with Chris. David and I attempted to pull together the board paper. I didn't analyse the various facets of it. I was just interested in populating a board paper for Chris to sign off.
Well, let's see about that, because if we go up, please, to the bottom of page 1, this is your email, 14th of December. Thanks, Jarnail. This is very helpful and does, I think, clarify the position very helpfully. Just one question of further clarification from me. In para 4(3), the note says, and then you quote from it, that protection would not be available to an organisation which conducted its prosecutions, quotes, in-house, that is, in Poll's case, using lawyers employed directly by Poll. And you say, am I right in interpreting this as meaning that as Post Office does not conduct its prosecutions in-house, that is, it uses Cartwright King rather than directly employed lawyers, any claim for malicious prosecution would properly stand against Cartwright King and not Poll, provided we follow our normal processes as described in the advice. Now, you have managed to get to the nub of it, haven't you, Ms. Cortes-Martin, in this email? You are clearly analysing the lawyers' advices, and you are using their advices and seeking further clarification so that you can write a detailed and careful board paper about whether there is going to be any action taken against them, board members. Yes?
Yes, I think so. I'm trying to put together the position and clarify the position so that I can put in the board paper. Yes.
Yes. And so your earlier answer, in which you tried to suggest that you hadn't really dug into this and you didn't really know much about it, is not true, is it? You had looked into it carefully enough to be able to analyse this proposition that claims for malicious prosecution would stand against Cartwright King and not Poll. Yes?
I've looked at it enough to try and make sure that the board paper answers the questions that I think Chris wants it to answer, yes.
And you obviously read the advice very carefully.
I'm sure in terms of picking out the bit that I needed, yeah.
Are you sure you didn't know about the content of Mr. Clark's other advice from July of 2013?
So, to the best of my recollection, I was not aware of it. As I explained this morning, so it's clear that it passed my desk, but at that point, I'm as sure as I can be that I wasn't aware of it.
Even though that was the advice which generated the board's concerns about past prosecution and the potential for their personal liability for malicious prosecution?
I don't know that was the case, because I don't know what the board were told about the Clark advice.
Is that an answer that you've felt you had to make because you don't want to put the board in it in some way?
Absolutely not. I am as keen as many other people to understand who knew what and when. I have seen nothing that suggests either way, whether the board knew about it or not. But I certainly would not say anything to this inquiry to protect anybody.
Could we have a look, please, at your statement, page 25, paragraph 53? Thank you. I do not know if any senior managers and/or directors of Pole were concerned about personal liability for malicious prosecution. If it were ever discussed in my presence, I have no recollection of it. Now, we've just discovered, haven't we, Miss Cortes-Martin, that you were deeply involved in advising the board on that very subject, weren't you? Something you forgot about when you made your statement?
No, as I said earlier, I took that question very literally, and I didn't know that they were particularly worried about it or if they just asked advice on it.
Really?
The board, really. At this stage, I had never attended a board meeting, to the best of my recollection, on anything at all to do with this subject. It was an entirely new subject to me. This subject matter was an entirely new subject to me. So if the action arose out of a worry about it, then I wasn't aware of it. If I take it in a more general sense, then if the underlying reason for requesting this advice was concern, then perhaps my answer's incorrect.
You didn't think you'd mention this work that you did, even though the question was about concern, you didn't think you'd mention this board paper? No, evidently not. Thank you. Those are my questions, sir.
Thank you, Ms. Page. Is that it, Ms. Price?
Yes, it is, sir.
Just to prolong it for 2 minutes, can you just talk me through how your recollection of how an individual application to the scheme actually got from the beginning to the end, so that I can be clear that I understand it, all right? And let me simplify it by letting you know what I think happened, and then you can correct me if I'm wrong, all right? So it would start with Mr. X or Miss Y making an application on a questionnaire, as I understand it. Is that step one?
Yes. Yes, I believe
something would have to instigate it. So a sub-postmaster would fill in a questionnaire and send it off to you, or you as the head, so to speak, of administering the scheme. So that would instigate their desire to engage in mediation with the post office. Yeah?
Yes, I think so. The reason I'm hesitating is I can't remember the point at which the detailed questionnaire was filled in, but there was certainly an initial, I want to be in the scheme.
Anyway, yeah, if you like, I want to be part of the scheme, and then shortly thereafter, or at the same time, they fill in a detailed questionnaire.
Yes, that's
right.
Correct.
The questionnaire goes to second sight, and it goes to the post office.
Yes.
Or is it sequential? Does it go to both at the same time, or does it go to the post office first to investigate?
To be absolutely accurate on this, I would need to go back to the scheme documentation, but I think
anyway,
it would have been available to both. It would have been available to both, but the action would be with second sight.
Yeah. But the way I've understood it is that the post office would then produce its response to the application, and then second sight would investigate that response. Is that right?
Yes, second sight would review the post office's investigation report and the evidence provided by the applicant and Post Office.
Right. Now, if they both said this is fit for mediation, that's fine and that's easy. If Post Office said it's not fit for mediation, but Second Sight on review said that it was, what would happen then?
There would be a discussion at the working group.
Yeah.
And I think there were a couple of changes during the lifetime of the scheme, but a decision would be made. If there was no agreement, I think Sir Anthony Hooper would adjudicate insofar as he would say it should be mediated. It would then be passed to...
Well, not so fast. So
Sorry.
If they haven't agreed, so it's discussed in working group, at the end of the discussion, they might still not agree.
Yes.
In which case, Sir Anthony would say, well, actually, I think I'm with the Post Office, so it won't go any further, or I think it should be mediated, and they would abide by his decision. Is that fair?
Not exactly. So,
That's what I thought. So you tell me what would happen then.
So Sir Anthony Hooper would decide whether or not he thinks it was appropriate for mediation, and therefore it would be a matter for Post Office to decide whether or not it wanted to mediate.
Exactly, because we're talking about a mediation, not an arbitration.
Yes.
Fine. So let's assume that against its better judgment, in inverted commas, Post Office accepts Sir Anthony's recommendation and says, okay, we'll mediate, even though they don't really want to. The next step is to provide information to the mediator, I guess.
Yes.
And that would be the detailed questionnaire, the Post Office's response to it, and Second Sight's review of it.
Yes.
Anything else?
Yes. As the scheme progressed, a facts file was produced, which was available to the mediator. And after Second Sight's part, so anything that Second Sight had produced as a generic report would also be passed to the mediator.
Be part of that. All right. So the mediator gets all that information.
Yes.
And then on the appointed day, the applicant, either represented or unrepresented, as the case may be, appears. The Post Office appear, by lawyers, no doubt, and the mediator is present, and a mediation occurs.
Yes.
And the mediator tries to nudge parties into an agreement, and sometimes it works and sometimes it doesn't.
Yes.
But ultimately, it only works if both agree. Nobody forces people to do anything unless the applicant and the Post Office agree on the result. It fails, the mediation fails.
That's correct.
And so when people talk about having the power to decide, the reality is that the applicant could say, for the sake of argument, I want £10,000, and the Post Office could say, we'll only give you £2,500, and it could fail, or they could agree on £5,000.
Yes.
That's the way it went.
Yes.
Just like any other mediation, in fact, once
yes.
we got to that stage.
Yes.
And so, in your experience, of the 150 cases, and I'll ask the Post Office to give me precise figures, but just so I can get a feel for it now, we know that there were approximately 150 cases. In your experience, approximately how many of them succeeded in the sense there was an agreement? And I'm not asking for a precise figure, just a feel at the moment.
So up until the time I left, and I really can't give you a figure, but what I can tell you is that I think CEDA, the mediation organisation, did a report for the working group, or it may have been the select committee, but the figures are set out in that, and it's actually in my evidence pack.
There's a document which will give me the precise figures.
But they said that the number of fully settled or fully agreed cases was slightly below the average.
Okay, don't worry. If you can't, you can't. I'll get it from another source. Well, I'm glad at least I understood the process of the mediation, so thank you very much. So those are my questions, and thank you for making your detailed witness statement, and thank you for giving evidence to the inquiry today.
Thank you.
So that brings us to an end of today's proceedings, Ms. Price, and it's Mr. Altman tomorrow, is it?
Yes, sir, that's correct. 9:45 tomorrow.
Right. All right. Thank you very much.
Sir.
switched the water as well. Yeah. You haven't touched yours.
Folks, we're still on schedule for 5:15 for the Minister arriving. So can I suggest we take a 10-minute comfort break then and let these officials stretch their legs? If anybody can ask questions before that. No?
Okay, thank you.
Thank you. Thanks a million, guys. That was useful.
Thanks, Father.
Yeah, I'm fine. Yeah, it was straightforward. It's grand.
Hi, Stephen. How are you? They're coming through.
Afternoon, folks. Thanks for coming, and I hope you've had some time to go through the report or put any questions to the officials. So the Minister is just going to make an opening statement about the report, and then happy to take some questions. You might just say what organisation you're with, if it's okay, and we will definitely get round to everybody here. So thanks again, and Minister, if you'd like to go ahead.
Thank you. Good evening, everybody. Last July, Government decided to commission reviews of governance and culture and of contractor fees, HR and other matters in RTE from 2 expert advisory committees. The purpose of these reviews was to address many of the core issues that gave rise to the governance and other failures we have witnessed in RTE and to make recommendations to address them. I also exercised my powers under Section 109(7)A of the Broadcasting Act to appoint forensic accountants Mazars to examine the RTE barter account and identify whether RTE held any other off-balance sheet accounts. The reports on Toy Show the Musical and RTE's 2017 and 2021 voluntary exit programmes, published earlier this year, brought to light in considerable detail more governance failures in RTE. Mazars' final report, which I published today, which includes the results of a detailed examination of every transaction made through the barter account from 2017 to 2022, provides further evidence of poor governance. I will be writing to the RTE Chair regarding the findings of Mazar's report and to seek a review of hospitality and travel and subsistence expenditure reported to Ministers over the period 2017 to 2022. Each of these fact-finding reports demonstrates why it was so important that Government agreed last July to commission reviews which would make forward-looking recommendations to chart a future path for RTE. And I have today published those reviews. The 116 recommendations made by the expert advisory committees are a blueprint for the further reform of RTE. If they are implemented in full, I am confident that they will improve the governance of RTE, both internally and externally, and ensure that the culture of the organisation better reflects the values of public service broadcasting that are so clearly demonstrated by RTE staff every day. The reviews point the way to a more inclusive, transparent and accountable organisation, one that truly has the character of public service. The recommendations will require an approach to presenter pay that is transparent, consistent, fair, clear and sustainable. They will bring further transparency on the remuneration of top earners in RTE, both on air and off air. They will endow the RTE board with the authority and skills to strategically direct RTE on behalf of and for the benefit of the public. Most importantly, they will ensure that the RTE leadership team is accountable to the RTE board and ultimately to the Oireachtas. Each of the members of the Expert Advisory Committee is an expert in their field, and I would like to recognise the enormous commitment they have made through this process. Their comprehensive reviews are a testament to their expertise and to their dedication to their task. That is why the Government today considered the recommendations made by the Expert Advisory Committees and agreed to accept them in principle, recognising that the vast majority of them will require implementation by RTE. To that end, I have asked RTE to prepare an implementation plan for submission to my department within 6 weeks, setting out detailed actions and timelines. I spoke to the Chair of RTE Board and the Director General, and they have assured me that RTE accepts the recommendations of the committees in principle and that they are fully committed to the process of implementation. The reviews I have published today make clear that the governance of RTE requires radical reform. While much of the work must be carried out by the RTE Board and leadership team, the review of governance and culture found that the legislative framework underpinning the governance of RTE contained in the Broadcasting Act needs fundamental reform. The proposal to reinstate the Controller and Auditor General to RTE has been one that I have been considering since the crisis in RTE first emerged. I also want to acknowledge that it is one of the key recommendations made by the Public Accounts Committee in their own recommendations. Given the recommendations of the Review of Governance and Culture and of the Public Accounts Committee, Government today agreed to move forward on this issue. I therefore intend to prepare and bring forward detailed legislative proposals to Government to assign the Controller and Auditor General as Auditor of RTE and to ensure that RTE is directly accountable to the Public Accounts Committee for their expenditure. I will also bring forward legislative measures to enhance the duties and strengthen the role and authority of the RTE Board and to ensure that the Director General is accountable to the RTE Board. As I said earlier today, the Chair and the DG of RTE both give me a clear commitment that RTE accept the commitments of the reviews in principle and will implement the recommendations of the expert advisory committees. On foot of this, I intend, with the agreement of the Minister for Public Expenditure, NDP, Delivery and Reform, to release the first tranche of €40 million in additional Exchequer resources allocated to RTE this year. The dispersal of the final tranche later this year will be subject to a satisfactory assessment of RTE's updates on the implementation of the plan by my department and the further agreement of the Minister for Public Expenditure, NDP, Delivery and Reform. The legislative measures I have announced today and the full implementation of the recommendations of the expert advisory committees by RTE will provide part of the scaffolding for a new framework for public service media in our country. They will provide the basis for the restoration of the trust and confidence of the people and Oireachtas in RTE. However, this framework will be incomplete unless it rests on the foundation of a funding model capable of delivering stability and certainty for public service media and a regulatory model capable of both ensuring its independence from government and assessing its performance. Bringing forward a robust implementation plan will also therefore be a prerequisite for the Government making a decision before the summer recess on the future funding model for public service broadcasting. I have signalled my determination to do so, not just to finally put RTE on a sustainable footing, but to underpin trustworthy news and Irish content right across the audiovisual sector. Mar curthaí bhaim na multi seo a tháinig ó na hafraithe atá fuilse go manú, tám lán cinnte go mé RTE athnúte, inmhúnathe agus iontaofa a agin. Táisí seo tiltte ag muintir na hÉireann.
Thank you, Minister. Just to say, this is being streamed, so if it's okay, we'll just be getting the mics to people, and I get round to each one of you, and the Minister's statement is also up online that you just read. So, Gavin Riley, if you want to kick off things there, just at the front.
Thank you. Gavin Riley from Virgin Media News. Can you clarify, Minister, whether in bringing forward the changes to the Broadcasting Act, will that also include whatever decision you make on the future of the licence fee, or will they have to be done as two separate pieces of legislation? And also, can you give a breakdown of how much of the 40 million, what size the first tranche you intend to be, and then how much you're holding in reserve pending its implementation?
Yes, so on the first, I would intend any legislative changes needed on the Broadcasting Act will all be done together. So that includes the funding with the CNAG, and on the first tranche, be €20 million.
Tig from the Examiner here.
Minister, how long do you anticipate it will take for legislation to be prepared on bringing RTE under the CNAG?
So that's why we're going to work in the department on an implementation plan for ourselves, as well as expecting the one from RT within 6 weeks. So we'll be able to give timescales on that. But realistically, I think it'll be towards the autumn, winter that you'd have that general scheme and then move to legislate. Well, I hope it depends, to be honest, because there could be a number of issues being amended within the Broadcasting Act, because the funding will be there, the CNAG will be there, the role of the DG being accountable to PAC, the DG being directly accountable to and appointed by the board as well. So there'll be a number of issues in there. But we'll have a better line of sight of that when we work on our, I think there's 15 recommendations for either the department or government, and we'll have those within 6 weeks too.
Just Louise, the front here, and then Brian.
Hi, Louise Byrne from the Irish Mirror. Minister, can I just ask on the idea of salary bands, do you have any anticipation or expectation of RTE that will ensure that some of those really high presenter salaries will come down? I know the DG said that no one should be paid more than him, which is 250,000, but do you expect that the implementation of those bans will bring those salaries down even further? And then on the cost, it's already up over €500,000 of all of these reports, and that could reach €1 million, we're told. Do you have any regrets that the department has to pay out all this money to essentially fix problems that are not your fault and were caused by RTE?
On the bans, I would expect the cap to remain in place, the 250, but what is in the recommendations is clarity about that 250, and is it base or does it include allowances? So I think that's something that RTE need to look at, but I would expect that to remain as the cap. And in relation to the bans, I think that's something that's to be welcomed. I think there's a focus in this HR report in relation to providing better opportunities for people to progress, that's transparent, that it's fair, and indeed in nurturing talent within RTE. In relation to the cost of the reviews, yes, to date it's about 574,000 that has been spent, and it could reach just over $1 million. But I do believe that the reports represent value for money. I think today is the first day where we can really see there's a path forward. We're future looking for RT and indeed for public service media. But I do believe the scale of the financial, organisational and reputational issues in RTE merited this root and branch review and examination, and the fact that we have 116 recommendations. I think more importantly, the fact that we are in a position now today where I'm saying we accept all the recommendations of government, the 15 to do with us, but more importantly RTE is accepting their recommendations, and we're looking to implementation plan, to moving forward, funding model, and that will underpin everything.
Have you considered at all asking RTE to go halves with you on all these reports, or are you happy enough to put the whole bill?
No, I think RTE have paid for their own reports over the past year, and these were government-issued reports, and that was clear from the beginning.
Brian, Paul Cunningham, and then Paul Hossard.
Hi, Minister. Brian Matton from the Irish Daily Mail. Two questions. One of the reports says that any future redundancy scheme should have a cap, and that the formula for the cap should be made public. Obviously, we know Breed O'Keefe got 450 grand. Do you have a figure in mind for what this cap should be? And then, secondly, in the overall governance report, it says the board appointment process operated by the Minister and the Oireachtas did not address important skills gaps that undermined governance and assurances in RTE and also left vacancies for considerable periods, resulting in a board spread thinly. Do you accept your role in not appointing the correct people to the board that might have improved the culture within it?
I think the cap, the RTE, that's a recommendation for them, and that's something that they will set, and we'll see what comes out in the next 6 weeks. In relation to the Oireachtas Committee gap, firstly to say that we have a full complement of the board now, and I'm very satisfied with the skill set that is there. I think what the report is really referring to are the four that are appointed by the Joint Oireachtas Committee. That's the gap they were talking about. And sorry? They recommend to me, and then I bring that to government. So the first delay there was the government being formed June, and then I think the Oireachtas Committee didn't start the pass process until November, and then the skills they were brought names to me, and I actually wrote to the committee asking were they really satisfied that the skill set was satisfactory. No, I'm just saying that well, obviously I brought them to government, but I'm just trying to explain the delay in that period. So it was the formation of government, then they weren't advertised till November. When they were brought to me, I just queried, I thought it was worthy of writing to the committee to say, are you absolutely satisfied there's no conflict of interest here, that there's the proper skill set, and they wrote back confirming same, so then the appointments were made. But I do think that we should make sure that the skill set, and we accept the recommendations of working with the Joint Oireachtas Committee, making sure that how they're advertised for, how the board conveys and links in with us to make sure that we are definitely putting the right skill set on that board. I think it's also about the skills for such a complex, large organisation that it's essential that the right people are put.
Pretty blunt. It says senior RT executives didn't provide info to the board, they didn't provide info to each other, and they also didn't provide some information to, I think, external auditors. Is anyone who is still left on the senior RT executive team from that time, do you have confidence in them to stay in those roles? As I said, this is the forward-looking piece. That's where we are today, and I have confidence in the interim leadership team as it stands and in the board.
Thanks, Brian. Paul Cunningham, then Paul Hosford, Fiona Sheen, Adam Higgins and Cormac McQuinn.
Just with regard to the statement you made at the outset, which is that all 116 recommendations need to be implemented in full. There was no equivocation. What happens if there's a bump in the road, if there's an issue, unforeseen issue? How are you going to ensure over the course of time that everything is done the way it's supposed to be done? Or could there be grounds for movement in one of the recommendations? And that's Os Burla and Os Gaeilge, if you could, what's the key finding for you, Os Gaeilge, Moshe Dahuli?
What I would say in relation to that, there will be a monitoring group set up by the department with New Era that will check in for, quarterly with RTE to make sure the recommendations are being implemented. And I think the committees themselves did say that it will take time, some of these recommendations. They're not all something that can be done within a few months, and we have to have patience with that too. But there is going to be that monitoring unit set up with our own officials and with New Era. I suppose in Uri rinne the máiste suntasach the winning an phobal in RTE agus sna tuirsci agus sna céad agus a héindeag multi atá fulsethe inu tá plan inis den RTE agus mar curthaí bhaim go homláin iad sílam actually Tom Kintha go bheabhsóí siad riadachas RTE agus culture RTE. So I think in mass na multi-sí an tardrachtar cúntas agus ciste capamar inúcar RTE tá sé sin an a tábhachtach agus an culture in RTE le gach den atá gobair sin.
Just Paul Hosford.
Paul Hosford from the Irish Examiner. Minister, just come back to something that Tyg touched on, the timeline here. There's been a pretty strong commitment from this government to have the future of RTE and to have all of the issues at RTE sorted in the lifetime of this government. You're saying that the general scheme of this bill probably not till autumn. Are you 100% confident that you will have an answer for the future of RTE in the lifetime of this government?
In relation to the funding?
Funding, culture, governance, everything.
The funding model, we will definitely have that decision before the summer, and that was something that we agreed at Cabinet today too. That was discussed with Cabinet colleagues. I can move as quickly as possible on this, and that's what I'll be doing. If time is, I suppose, slightly against me due to as far as this government can go, but I am focused on moving this as fast as possible. As I said, there are a number of amendments that will have to be made to the Broadcasting Act, but key will be that implementation plan with the timelines, and we'll have more clarity on that in 6 weeks' time.
And would you be okay then leaving this to the next government, leaving those legislative changes, if that's what has to be done?
Well, look, I would hope we could get it done, and if it can't, it will be a case for the next government to implement that, and I would hope that any government that is in place after the next election would take very seriously the key recommendations from 2 expert groups that is putting RTE and public service broadcasting on a sure footing.
Thanks.
Fiona, followed by Adam, Cormac and Killian.
So, Minister, I have 3 questions for you. The first is on the model of future funding. Is it still your view that the Exchequer funding model should be on the table, including the abolition of the TV licence, as you stated last December?
Oh, well, I thought you were going to 3. Look, we're down to, in my opinion, 2 models, either revenue collected or the Exchequer funded model. I believe, I've stated before, I see, risks with every model, but I do believe what the Future Media Commission has recommended originally has great merit, more so now in light of what emerged in RTE, and I do believe safeguards can be put in place. But this is very much still up for discussion. There's differences of opinion, but we are absolutely united in Cabinet that the decision will be taken before the summer.
And just secondly, on the governance and culture report, on follow up that previous question about the board, it's pretty scathing. The silos operating, the lack of trust, the perceived threat of leaks, the limited appetite to learn. How do you have confidence in people who were on that board prior to these scandals all emerging a year ago?
As I said, this is the future-looking piece that is making sure that this never happens again. I do have confidence in the board, and I've stated that today and in previous occasions on how they are operating now. And I think that's what is important. We have some reforms that have come in place, and more will happen on foot of these recommendations.
So, a third question then on a related issue. Ireland is participating in the Eurovision this week. You've previously attended events where artists have boycotted them on the basis of disputes around the Israeli conflict in Gaza. Do you believe it's appropriate for Ireland to be participating in the Eurovision this week?
Well, I think involvement in the Eurovision Song Contest is a matter for RTE, and as Minister, I do not want to get involved or try to influence any decision. It still stands that I believe in artistic freedom, and I'm not going to interfere in any individual artist to participate or not participate. I think our entry has been. I watched last night some of the sneak previews, and I think they are doing a great job on this. But as I said, it's not that I, as Minister, I would want to influence any decision, Fiona, or I think that would be wrong. But again, I respect artistic freedom.
Adam.
Well, look, I wish them the very best luck. The odds are looking good for them today, and I wish them the very best luck in that. But as I said, the EBU, I suppose, who organised the event, who previously stated the event, should be about songs and shouldn't be politicised. So I think that's what they're saying as well, our entry.
Minister, the TV licence decision before the summer, but the legislation won't get through until around the winter. So, I mean, if there's an election before then, does that mean that it'll be up to the next? First of all, I suppose that means the TV licence survives until 2025, and then it's up to the next government, I suppose, to actually decide whether to end it or not.
That might be the case, Adam. Yes, if we don't have the time to implement it, but I think the work that we have done in getting these reports, getting the recommendations, if we are the first government where consecutive governments have failed in taking a decision on funding, I think that's something that should be followed through by all political parties. If it's in a general election, they should commit to that. If we don't get the time to get over the line, but I'm not saying no to that yet. If we run full term and we want to run full term, we might well have the time to do that. And that's what I would really hope for.
And secondly, at other press conferences throughout the past year, we've asked you about accountability, that nobody seems to have been held accountable for all these scandals that happened in RTE. And repeatedly you said that you wanted to see these reports, because they had recommendations. So will there now be accountability for RTE, and will any punishments or accountability be seen by the public for all this?
I think accountability takes many different shapes and forms, and appearing before Oireachtas committees is one of the ways that does happen. Unfortunately, we do have some who didn't participate, and that is definitely regrettable. But I think what we have here is a case where RTE are in a position now where they're accepting the recommendations, which I felt was really necessary to happen. 116, and only 15 of those are relevant to government or my department. So I think that implementation of change and moving forward, this is really about charting the path forward for RT. That's the space we're in now, and I think that's where we need to be. It
just seems that the only punishment for all the scandals that we've seen over the past year is now, okay, fix it. And as has been pointed out, some of those people are still involved in fixing the problems that they were in charge of.
Yeah, well, as I said, I've confidence in how the board and the interim leadership team are operating now. We have seen huge improvements in the working relationship and the reforms that are taking place. And I think, apart from even these recommendations, we'd expect to see the strategy in the coming weeks too. And I think it's really important that this is the moment to move forward for RTE.
When you say it's regrettable that people can attend, do you mean deforms?
Well, I've always said that it would be much better if the former DG did attend before committee.
Do you think, in the context of these reports being published now, do you think that there's no more need for her to come forward, or would you still urge her to come forward if she's out there listening to this or reading what you're saying?
Well, I believe she's on well, so as soon as she is in a fit state to attend, I'm hoping that's something that she'll do, but she is on well at the moment.
Cormac, Ben, Gabby, and then we'll go back over to the other side, Daniel and Co. Thanks.
Minister, you said
Killian after Cormac. I beg your pardon, Killian.
Minister, you said there's two models under consideration for the future funding of public service broadcasting, and that exchequer funding, as recommended by the Media Commission, still has great merit, and that the whole issue is still very much up for discussion. The other model seems to be a reduced TV licence fee that would be collected by revenue. What's the downside of that? Wouldn't a reduced fee result in more people paying?
A hybrid type model, is it?
Yeah.
It's not something that any group has recommended to me. It's not something that was discussed by the Future Media Commission. It's not something that the technical working group looked at. And I think what really needs to be done in relation to the future funding model, it needs to be credible, it needs to be sustainable, it needs to have public acceptance, and be free from political interference.
We've been reporting that the likely outcome is a reduced TV licence fee collected by revenue, that this is one of the options under consideration by government. What's the downside of that? I know you're in favour of direct exchequer funding.
I know you've been reporting that and saying that that's not any recommendation that I've received, Cormac, but I think we have to be careful you don't end up with the worst of both worlds, where you have exchequer funding competing in the annual budget process and bringing in maybe another 500,000 houses in to pay, even if it's a reduced fee or tax. So we just need to be careful on that.
Very much still a supporter of the exchequer funding model, Director.
Look, you just asked what are the pros and cons, and I've outlined them. But as I said, there's no group that has recommended that particular model to me. I've looked at what the technical working group have done detailed research on a reformed TV licence model. I've looked at those recommendations, and I've looked at the Future of Media Commission recommendations.
Killian, Ben, Gabi, and then over there.
Hiya. You're spending €1 million on these reports, and you've told us over the last year about how these are the be-all and end-all for in terms of making recommendations before a decision on the future funding model. How can you really say that you have a sense of the culture and governance within RTE when these experts didn't actually talk to staff members and they put out a staff survey that more than 75% of them ignored?
Well, I think we had experts on the HR group that are well respected by the unions in RTE. I'm hopeful that those unions will see the merit in the recommendations here, and I think this is really about improving the culture within RTE, from a gender equality, inclusivity, diversity to giving opportunities to progress, to have your talent nurtured, and to see fairness, transparency and equality. And I really think, as I said, if these recommendations are implemented, I do think we'll have much stronger governance internally and externally, and a culture for the staff that is replicates the actual public service that they are providing on a daily basis.
Yeah, but how do you know anything about the culture of RTE when 3/4 of them didn't respond to the survey, which is the only way that they were able to give feedback to this expert group?
But they would have engaged through the surveys, and we can see that the change that is seen there over the year, that the culture seems to be improving, or they're seeing better communication.
Ben, Gabi, and then across. Sorry, Gabi. It's okay.
Minister, firstly, sort of in relation to Adam's point, given everything that's come to light about RTE, is it not the case that the government rushing to the broadcasters' aid financially is effectively like rewarding failure and irresponsible conduct on the part of a major semi-state body?
I think what we really need to do here is where consecutive governments have failed in putting in place a sustainable funding model for RTE, and remember that this sustainable funding model isn't just about RTE. The funding model we decide on will be for TG Cahir. It would also be for local and newspapers, for local broadcast media too. So it's about public service media. So it's about, as the Future Media Commission said years ago, about doing a public good. And I think it's about time, and we will be the government that will take that decision. And I think we're in a position to do that now that RTE have agreed to take the recommendations on board.
But again, as I say, sort of in the same vein as what Adam was saying earlier about accountability, that if the consequence for conducting yourself in the way RTE has done for so many years, which you accept is unacceptable, and that's why all these recommendations are needed, if the consequence for that is just to be supported with a better funding model, is that really an appropriate response to a crisis? I mean, is it not, as I said, effectively rewarding failure and irresponsibility?
It's about value in public service media in an era where we certainly need trustworthy news, where it's about providing culture, sport programmes, children's programmes, Irish language programmes, reaching out to our youth. And I think the funding model will be agreed on foot of seeing this in-depth route and branch reform being implemented.
That's not really an answer, but I'll just ask one more question. On RTE's HR and governance policy, I see here in the report that one of their key goals has been diversity and setting a number of DEI quotas where they aim to have a certain number of staff and presenters who are, for example, women, ethnic minorities, members of the LGBT community and so on. And specifically, they say that they're hoping to have 4% of staff identifying as LGBT as a preliminary figure. I'm just wondering, how is that tracked? Because it seems legally dubious, obviously under equality law, to ask about somebody's sexuality in a job interview. Are you aware of there being a way that that's actually measured to attain that target?
What I would say is I really welcome the inclusivity, diversity and gender issues being addressed in this, and I think it's a really positive day. It's something that was raised with me, with the unions, with staff on numerous occasions since this crisis emerged, and I'm really glad to see that this has been addressed and it's charting a path forward in relation to that too.
Thanks, Mark.
Specifically, I mean, I asked 2 questions and I didn't get an answer to either of them, Minister. As I say, if you don't know, that's an answer, but I'm wondering, are you aware of how those specific targets are tracked and measured, particularly the ones that might involve an encroachment into a potential employee's privacy, where you might have to ask about their private life? As I say, saying I don't know is an answer, but
I would presume that everyone's individual rights would be respected. What I am saying is that I think it's a really positive day for inclusivity and diversity and for equality, and the recommendations that are being accepted here by RTE. I think it's a positive.
Mark, sorry, you might bring the mic down to Gabby there, so she's
just on the hybrid model, you're sort of ruling it out there, but it seems to be very much what is the thinking among government figures at the moment. I mean, I suppose in discussions, are you saying, I definitely don't want it, and can you guarantee that we're not going to have any sort of a hybrid model? You're also making the point that no government previously has been successful in overhauling the TV licence, despite many, many subsequent governments promising to do so. In fairness, your government hasn't accomplished that either, and what it sounds like in speaking to sources and from what you're saying today is that Cabinet is going to sign off on some sort of an outline of what the overhauled TV licence may look like. But realistically, the House of the Oireachtas is just not going to have the time to pass any of that legislation before the government collapses. And Sinn Féin want to abolish the TV licence if they are to be in government next time around.
As I said, there's a variety of opinions at the table, and we will come to an agreement in July because we're determined to do that. In relation to time, what I've said is I wanted to take the decision. I've always said I'd like us to be the ones to implement that decision too, and that's where we'll need the cooperation of the entire Oireachtas. We want opposition to cooperate with us as well. So if they're willing to help us prioritise this, to get this through the Houses for the sake of us all valuing public service media content, then it could be possible, Gabby, I think. But we need everyone to cooperate on this.
But you're saying it'll be the autumn before you bring forward any new laws to reform the television licence?
I think realistically I can bring the timeline in the next 6 weeks, but I think to get a general scheme together it would take to the autumn, and then we'll try and move as quickly as possible.
Sorry,
I won't be trying to slow down the process. I'm going to try and speed it up as much as possible.
Sorry, it's next 6 weeks for what?
For the implementation plan with the timelines, so for any of the legislative or admin changes that we have to make, I'm going to bring that to government as well as RT's implementation plan, so we'll have a better sense of that.
Yeah, but RT doesn't, RT's not going to implement those laws, government will. So it's up to you to bring forward the overhaul of the television licence and then pass it through the Oireachtas.
There are 15 recommendations for us, and I'm going to bring that to government, the implementation plan for those 15 in 6 weeks' time. On the same day, I'm going to bring the other recommendations, the vast majority for RT and their implementation plan. I'm just saying both the implementation plans will come together. I felt it was important if RTE was bringing their implementation plan with timelines that I would do same.
So the same day when you bring forward whatever the RT plan is, I'm talking about the overhaul of the TV licence, that's going to happen that same day?
You'll have the timeline then, yeah.
Okay.
For the new laws to pass, so that we know what the
It will be an implementation plan for all the legislative changes that will happen. That would include the funding. If we get that decision, we'll outline when it will happen then.
So the decision will have to be made before, in the next, before the next 6 weeks, so that...
No, it will indicate how quickly it can happen, because the Broadcasting Act will have to be amended for it as well. So we'll be indicating when we bring in those amendments before the Houses.
Right. Thanks very much. Daniel, we'll just cross over to the other side there. And we've just time for one or two more after Daniel.
Daniel Murray from the Business Post. Minister, I think you said off the back of the barter account review that you are to order RTE to review wider expenses for travel and hospitality. Is that to be another external review, and what's the timeline for it? And how concerned are you by what you've seen in the barter account report that has led you to order this wider review?
I think that's really in relation to the comprehensive report that was meant to accompany every annual report, that comprehensive letter from the Chair that was meant to reveal those expenses, the travel expenses, the hospitality, and it didn't from 2017 to 2022. So I conveyed to the Chair today that I'll be writing formally saying I want absolute assurances and clarity that we will have that in future. There was a confidentiality agreement agreed with the Minister in 2017 that would happen. Those details would be in a letter that would accompany the report from the Chair, but it wasn't there. And I don't believe that was the Chair's fault. It was probably because it wasn't to be seen anywhere. But in future the reforms are in place, and I've asked for absolute clarity on that.
Thanks, Minister. Ashley? Sorry. I beg your pardon. Sorry, Claire. Sorry.
Just on that barter account, just following up from Daniel's question on the fact that there were misclassifications within the barter account. Do you need further clarity on those misclassifications? Are you concerned that you were misled? Is that your understanding?
In relation to the various expenses? Yeah, that were deemed as not having any valid reason or the processes in place. But I think the main thing is that the barter account now is not used for purchase and service or goods since last April. And as I said in the forward-looking piece, I'm confident that the barter account will be used with the proper processes around it for the proper reasons. I think a barter account is sort of normal for a media organisation. It was the operation of it that was incorrect.
Okay, and we'll one more from Brian, and if it's okay, we need to wrap up then.
So, Minister, just to come back to the issue of resignations and the overall kind of exit packages, the report says here 4 senior RTE executives in position in June-July 2023 and were centrally involved in the events leading to our reviews have since retired. The extent of the financial arrangements concerning 2 of those departures from RTE have not been disclosed. Without knowing the details of any termination payments, we do not know whether there was a, quote, pay for failure, end quote. RTE are going to disclose some of the overall lump sum in their 2023 reports. But how can we still be here in April or May 2024 and not know the scale of this and whether these guys can't tell us whether there was a, quote, pay for failure thing going on within RTE for these senior people who resigned? I
think I have asked for that aggregate sum to be brought forward ahead of the annual report being given to me, and I would expect that in the coming days.
And will you publish that?
RTE will review that.
Yeah. So just on this pay for failure element, do you believe that there was a pay for failure culture within the highest levels of RTE? That people just went, do you know what, if I actually do something stupid and I have to get paid off, I'll get paid off and I'll run off into the sunset?
I think that's why we saw, that the recommendation, and I would have said it too, that these confidentiality clauses should have been the exception rather than the norm, and you can see that coming through in these reports too. How they were used was just not the right thing to do.
Do you
and that's
think
why
there was a pay for failure culture in RTE?
I think there was a use of those confidentiality clauses that was not respectful of the code of conduct of state bodies, and it should have been the exception, and instead it became the norm.
Okay.
Would it be reasonable to say that there was a culture of
pay
for failure in RTE?
What I'm saying is it should have been the exception and it was the norm. It was the norm, and I don't think it should have been the norm.
Thank you very much, folks.
Sure.
Just jumping on the calendar here, 6 weeks' time, June 18th, thereabouts. So we'll have our implementation timeline, and within that, let's call it June 18th, give or take a few days, we'll have a decision on the future funding model on that date.
Yeah, the funding model will be before the recess in July. When is that? The 11th, 12th, 13th of July. So we will definitely have the funding model decision before summer recess. And that was discussed today.
Right, okay.
So do you, just to further that, so when RTE do the 6-week implementation, I assume that you're going to want to sit down with that for a few weeks before you publish it?
It'll be brought to government when they give it to me.
Within the 6 weeks?
Yeah.
Okay, that's fine. Thank you.
Thanks very much. Thanks very much.
Is that the same day that the decision on future funding is going to be made?
I can't tell you, that's what you're trying to establish. I think Adam was as well. I can't tell you for sure it'll be the exact same day. All I can guarantee you is it'll be before the summer recess, the funding model. That we're absolutely committed to today. I met with the leaders, and there's an absolute commitment on that from all three leaders and myself.
All right, Coach.
I'm saying before the summer recess we will have. There's two things. I know it's confusing. There's the funding model will definitely be decided on before, say, middle of July, before the summer recess. The implementation plan I've asked RTE to bring within 6 weeks, because I want to see them not only just accepting the recommendation, but showing me how they're going to do it.
Okay. So 2 months' time? 9 weeks, 2 months' time, like, is that where we...
About the funding model?
No, yes, funding model.
The funding model will be, I think we get our break, if you look up on the calendar, summer, it's usually around the middle of July. That decision will be taken before then. But I just can't guarantee you what week it is.
Louise.
It may not necessarily come together yet.
Okay, thank you. And
Okay.
I think RT are releasing a statement as well shortly.
Thank you.